Yes. The meat of mother just yes, extremely urgent situation. On the single text, there is a inform Mr. Ramesh and Mr. Citizenship immediate. Is it happening in the list? Item number 33, because I fear it may not be. We have filed advance notice, everything has been done. For the single bench, any time. Sure. Even if the interim prayer cannot be allowed, just an interim prayer to protect. Today, the request has been made by the bar that there's a farewell you are giving to the judges. So therefore, we have to request it. We have been requested to rise at 1:30. So we'll take it up at say 1:15. I'll take it. Already given the advance copies. 1:15. And Mr. Prepare yourself. It is literally a matter of life and death. Otherwise, I would not have done it. You take it up at 1. We have not received any instruction for appear. Take the instruction in the meantime. That's why take the advance copy. Take you up on. Take it up at 1 to 3. Yes. Yes, division bench. I take only 2 minutes, not more than 2 minutes. No, we call it in due course. It is fairly up in the list. So because you rise and all that. No. Yes, follow this. Accordingly, WPCT 14 of 2026 is dismissed on contest against the respondent number 1 and ex parte against the respondent numbers 2 to 4, thereby affirming the impugned judgment dated November such and such. They will order us to cause starting set for it. Yes. Right.
Filing period of opposition on behalf of respondents number 2 and 5.
So taking it on record, nobody is applying for the petitioner. We have already granted time. This is within time. Within the 2 weeks we have granted, beyond that. This is the opposition you are filing.
Not that.
We had 2 weeks had been granted by Justice Ghosh and Justice Chatterjee on March 10th. Very good. The affidavit in opposition filed today be kept on record. Full stop. The time for filing reply is extended for a week from date. Full stop. Let the matter be listed in the next step.
Respondent number 2 and 5.
Affidavit in opposition filed by the respondent numbers 2 and 5.
I already filed.
That is already on record. Yes. Now we'll record a line. You have a respondent number? Their affidavit is already on record. Is it already on record? 2 to 4. It is hereby recorded that the affidavit in opposition filed by respondent numbers 2 to 4 is already on record. File. দেখে তো সমস্যা শেষ হবে। Why is it appearing? What is the application? Filed within time?
Yes.
What is the reason given? Pardon? Come this side. Don't argue from there. Why are you arguing from the side? Come to the middle. No, come to the middle, this side. Miss Zinu will be there. You come here. You come here.
Yes, I'm sorry.
Yes. Yes, he was in Chennai.
Yes. And I suppose all medical documents also allow this application. On the date of hearing, my lord, he was at Chennai.
His medical document.
Yes.
Advocate's medical document is not required. Anyway, Ms. Zinu were allowing this.
For a few of the responses, Your Lordship, that is Respondent number 2, 3, 4, 5, and 8 only.
So you write on a slip of paper and give it. Heard learned counsel appearing for the appearing parties, pushed up in view of sufficient explanation for the absence of the appellant on the relevant date having been made out, comma, can 2 of 2026 is allowed on contest, comma, thereby recalling the order dated February 23, 2026 and restoring FAT. No, sorry. This is order dated. Section 5 is. There's a means of put it sorry, recalling the order date February 25, 2026 and restoring FAT 2 of 2026 along with CAN 1 of 2026 to their original file and number, no rest to cost. Acha, the section 5 we can hear out also. If you read. What is? Have you served copy on
Yes,
this?
yes, I have said, I also filed affidavit also to that effect of CAN application.
No,
Can-
not scans.
CAN 1, CAN.
Yes,
Section
it
five.
has been served for now. I filed affidavit of service.
You have filed.
Yes. Well, there is one difficult to make. If the
It's
appeal
not
is
been
restored, this cannot be taken up since the beginning of jurisdiction has been dissolved by the larger bench of this court. So this
Right.
matter has been delegated back to the district judge to take up.
This is not a matrimonial.
It's not a matter of it's regular.
Swiss will grant you leave to file whatever.
And we
At this juncture, comma, it is pointed out that in view of a larger bench decision of this court, comma, the district judge has paramount jurisdiction to take up all first appeals in the Andaman and Nicobar Islands. To sub next para. Accordingly, CAN 1 of 2026 is dismissed as not maintainable due to lack of pecuniary jurisdiction, comma, consequentially, FAT 2 of 2026 is also dismissed. Liberty is given to the appellant to prefer an appeal on the self-same grounds as taken in the present appeal before the concerned district court having jurisdiction, comma, along with the connected application for condonation and or otherwise, comma, if any. To next para, it is made clear that the merits of the matter have not been gone into. So no arrest to cost. The learned advocate on record for the appellant is granted liberty to take back the certified copies of the impugned judgment and degree upon furnishing photocopies thereof for the records.
one fair order.
Yes,
Time
yes.
consumed before this forum may be excluded.
No, we pray for that. We cannot. We don't have jurisdiction. We cannot say that. You'll get the benefit of. Ms. Zinu will tell you benefit of which section.
14. Okay.
Yes. Thank you.
Before WPA, they will have not been restored.
But comes the direction passed by this court, we have to file every status response rules with regard to the crisis of care. Because when we have filed the reports after that, there are various developments because
There are various. Sorry.
developments. Because we cannot able to file it by your report. In the current status,
Give the current status. We will take it on record, but we will also insist upon
like this. That happened, Malak. This is quite a serious public litigation, Malak.
Yes.
The island, Malak, particularly the North Andaman, was facing power crisis where they were shut down for about 12 hours a day. 12 hours power, 12 hours shut down. But at that particular point of time, Malak, came to our knowledge, the petitioner, that the Central Electricity Authority Malak, had asked for purchase of a 10 megawatt diesel generator for the islands. So when the file was mooted for the tendering process before the Lieutenant Governor rejected it, saying that you opt for green energy. In spite of the fact that it was approved by the Central Agency and the Lieutenant Governor had no authority to move it. Well, this matter came up for the first time before Honorable Justice Division Bench presided over by Honorable Justice 11th, my lord, to see the order dated 11th August 2025. Every bench, my lord, have taken a very serious view of
of this matter, and the authorities are approaching in a very casual manner. I'll take the sequence of events, my lord, what has happened and where we stand as on today. My lord, 11th August order, my lord. Relevant portion would be second page of the order, my lord. Last second page of the order.
Yes.
This court is surprised to find that the Central Electricity Authority had approved the proposal for purchase of 15 megawatt diesel generator, 9 megawatts for Chatham and 6 megawatts for Elizabeth during the year 2024. Despite such approval, the Lieutenant Governor turned down the tender process relating to the same with an observation that the administration should offer green energy. This court fails to understand under what authority the Lieutenant Governor turned down the process, despite the same being approved by the Central Electricity Authority. It is expected that the Lieutenant Governor shall take necessary steps for materialization of the proposal approved by the Central Electricity Authority in order to resolve the present crisis. And the other things follows thereafter. Then thereafter, my lord, the authorities were directed, my lord, to file a timeline report before this honorable court as to how they are going to bridge this gap, my lord, of the demand and supply. What is happening that the power generation is of two ways, my lord. One, the department is generating power through their generators, my lord, and second, the tender process where the private agencies come, they bring their generators. That's another factor. My lord, if a contractor is given to generate diesel power for 10 megawatts, he is bringing only 10 megawatts of generator. So there is no backup if there is a fault in one of his generators to cope up that.
Yes. Yes.
And there are outdated generators.
So that was give me half a second. I by mistake I brought my phone and just put it on 7. Please continue from there.
Hello.
Yes.
These followed by directed file timeline.
Yes.
I would say kindly for report which is dated 3rd September, my lord. It will be titled as reply to supplementary affidavit dated 7/8/2025.
Yes.
That would kindly come over
Yes.
page 7.
এটা কি আজকে দিচ্ছেন? না ঠিক আছে yes the page
Page 7 of the report. Page 7.
yes
Column 2 at paragraph G.
Right.
There is a tabulation.
yes
Now, timeline, allow me to see that the power requirement, my lord, I'll show my lords, was about 50 megawatts, my lord, during peak hours. 50 to 53. At least to that extent, possibly during summers, not it should have gone up. Definitely should have gone up. There are discrepancies in their reports, what they indicate. My lord, you see in August 2025, the total
yes August 2025 36 please say that. So what is the present position?
present position, one of the diesel generators, they have been, as per this timeline, my lord, the division bench presided over by Taylor, order with the machine possible and see 3rd September's order. I indicated that this timeline has to be strictly followed. So, my lord, this undertaking merges with the order of the any deviation, variation, in a very casual manner. So they keep coming, filing the report. We are not able to achieve it. We will do it by another 3 months, another 2 months. It is not at their whims and fancies. They should come seek an extension of time. What are the difficulties to be explained to the court. Now, one very interesting thing what is happening as of today. Possibly, we have reached almost to the point of demand and supply. There might be slight variation. Now, there is one agency, if I not would see, whose tender is expiring on 30th of April of this year, which is generating a capacity of 10 megawatt. Why I had mentioned, my lord, because we have few days of circuit left over, my lord, and peak summer is there, my lord. Everybody is going to suffer. The secretary, my lord, was present before this honorable court before a division bench decided to work on justice.
One of the division.
Just Prashant. An undertaking was given that if we are able to achieve the required generation capacity and the other lead generators come, we are going to extend the tenure of this contract in expiring on 30 years. And a report to that extent was also filed before this honorable court, my lord, that we are moving the file for extending it. Now, this is almost more than 1.5 months. Nothing has come on record till date whether they have extended it or not. Let them come, my lord, at least for the time being, that the term of the contract as
Yes, Mr. Kaur, what do you say regarding that extension? We have to do it immediately.
given para 5 we have mentioned. Sorry, not because
No, we'll see to that. First of all, let us see. Yes, para 5.
regard to the existing 10 megawatt higher plant under the power purchase agreement of the MS Express Genset.
Who is the competent authority?
Chief Secretary. For the contribution for people expand with effect from.
There is a question of any.
Not the Secretary Finances approved.
What is under approval? We don't understand this. The chief, the
Presently under approved.
competent authority is the chief secretary. Chief secretary.
Two of the earlier reports were the same sentence. Same sentence, same word, same phrase.
Under approval won't do. Sorry.
The commissioner is the competent.
Approve it by tomorrow. We'll take a report on Monday. By tomorrow. No further time. Sorry.
Very casual.
Other will be hauled up for contempt. It's your choice. The commissioner, if the commissioner prefers to come and move his matter himself in contempt, then we are agreeable to that. Before you leave the island, it has to be there. Do it by tomorrow. We are giving you till Saturday. We will take a report on Monday.
Getting expired on 30th April. Will you say that from first?
No, the bench will not be there. Sorry.
30th
It's
April?
continuing under the edges of the bench. Otherwise, you won't do it.
6 days left for April.
No. We want to do it by the end of this week. We'll take a report on Monday.
The honorable bench has taken a very serious view of the matter.
Monday, this we'll fix it.
The suffering.
We'll fix it at say 11:45 on Monday, so that you get some time to affirm the affidavit on Monday. Do it by Saturday. A serious energy crisis has been brought to our notice. The present public interest litigation was filed due to the extreme dearth of electricity in the Andaman and Nicobar Islands, particularly the South Andaman district. We find from the records that several reports were filed at various points of time by the administration, pursuant to directions of the court. We are apprised by learned counsel for the petitioners that before one of the coordinate benches, the chief secretary, the secretary power was personally present and assured that appropriate steps would be taken. Learned counsel submits that at present, the supply which has been ensured by the administration is near par with the demand, although there is some shortage. However, there is extreme urgency in the matter, particularly since one of the 10 megawatt power generators is being provided by a supplier whose contract is going to expire on April 30, 2026. That is within about a week from date. First up, next para, it is submitted that despite previous assurances, the contract of the said person has not been extended on an emergency basis. First up, next para, learned counsel appearing for the administration submits that due to circumstances beyond his control, comma, no affidavit could be prepared. So, however, comma, learned counsel files a current status stroke progress report, from which we find that it has merely been stated that the proposal to extend the agreement under the power purchase agreement of 10 megawatt, comma, which is due to expire on April 30, 2026, is double inverted under approval of the competent authority, CA capital, double inverted close. Question on query of court, comma, learned counsel apprises the court that the competent authority is the commissioner. Question next para. Since the power crisis hits at the very basic necessities of the islanders, comma, it is of utmost importance that exigent measures are taken by the administration to immediately extend the contract of the 10 megawatt power supply in order to ensure continuous power supply. Question next para. We are also aware of the fact that this circuit ends on April 28, 2026, that is about 5 days hereafter, and in the event the assurance given to the previous benches is not complied with by the authorities, comma, the islanders will be in serious trouble, comma, having no forum to ventilate their grievances. Which is next para. In view of the above, comma, we are not satisfied at all with the lip service paid to the earlier assurances by stating before the court that the proposal of extension is double inverted under approval, double inverted close. Which is next para. Accordingly, comma, keeping in view the extreme urgency, comma, we direct the commissioner, that is the competent authority, to immediately issue an appropriate order extending the contract of the supplier of the said 10 megawatt hired power plant for a reasonable period, comma, to ensure continuance of power supply. Such extension shall be granted by the end of this week, that is within that is on or before Saturday, comma, April 25, 2026. A report of compliance in that regard shall be filed in the form of an affidavit on Monday, comma, April 27, 2026 at 11:45 a.m., comma, when the matter shall next be taken up. List the matter accordingly. Subject. Next para. In the said affidavit, comma, the commissioner shall also indicate as to the current position with regard to the revival of 4 BG sets which are presently under repair, and as to exactly what steps are being taken to ensure that such repair work is done expeditiously. The parties shall act on the basis of the server copy of this order for the purpose of compliance without insisting upon prior production of a certificate.
Subject to my lord's acceptance. I already have said that may be extended for reasonable time. Instead of
What is the usual time for which it is?
If it can be to be extended till alternative arrangement is made by the subject.
No, but they don't know. That will be indefinite period. That will be an indefinite period.
At least for the time.
Reasonable period we have said because we don't know their situation. And on the next day, please remind us, Mr. Tabriz, we'll put in something in our order that before it expires, they have to either issue a tender and
There are previous orders to that. I'll take my.
no, we'll say that that has to be done within that period. Alternatively, we'll put in our order that this will be extended again.
They should put timeline for next 2 years, because the long time projects, my lord, is coming up only 2029. So that's
On an immediate basis, let this be done. That we
Step
can
by step.
step by step, at least let us see that this is done. Mr. Kumar, you please prevail upon your client, use your good office. No, the commissioner is holding up. We want the commissioner to come. No, it's pending for approval before the competent authority. The competent authority has to file that. We have directed the competent authority, the commissioner. Let there be no doubts about this, Mr. Kumar. We are on record. We are saying this. We are not asking the secretary. If we find that the affidavit has been affirmed by the secretary power and not by the commissioner, we'll haul it up. We'll haul up the person concerned. We have directed the competent authority, that is the commissioner, to grant the approval and grant the extension. And it is he who will file the compliance report, not the secretary power. We don't want scapegoats before us. We want the person concerned. So let us take the bull by the horns. Let us have another exercise like the previous one. Let us start with this. But Mr. Kumar, you have to prevail upon your client. Otherwise, we'll take serious steps. We're telling you. We'll direct personal affairs. We have still one more day after that.
Only electricity, water is the same issue here, once in 4 days.
Wait for the excitement.
Yeah, sought certain information that RTI.
We hope Mr. Kumar still remains in the panel.
Hey, he's doing his best. What
That
can
that
he
is
do?
why. That is the
What
reason.
can he do? If the matter
No, that is the
doesn't
reason.
merit,
That is the reason.
he can't.
That is the reason, Mr. Fabric. That he's doing his best. That's why you are apprehending. Yes. Oh, right. Yes. This is order first. Order টা কোথায়? Where is the order? She passed the order. তো অর্ডারটা পাস করার জন্য আছে তো। We are passing it over for a minute and we are taking up 6 and we'll pass the order. অর্ডারটা আনিয়ে নেবেন না আপনি কোর্ট অফিসার? রাখুন কলটা রাখুন কলটা রাখুন।
এটা রেখে দিন।
Yes. Sir, Shamant, please be as short as possible because you have limited time. Yes. No, you are very precise. You are very precise.
I request for the respondent.
Hey, Stephen,
Be
we'll just seek 1 minute's time from you. We'll just pass an order in the previous one. We'll just call the previous one again. 5 টা রাখুন আর Mobile 5. এটা থাক।
Sir, we have expunged that portion and set out certain, we have set out certain directions. It starts from paragraph 30, that the observations within the order dated 6/26 passed in the so-and-so is quoted in paragraph number 8 is hereby expunged. Number 1. The respondent number 3, being the statutory appellate authority, shall dispose of the appeal referred by the appellant against the demolition order number so-and-so within a period of 12 weeks. So that remains because it remains untouched. And respondent number 3 shall decide the appeal independently on its own merits and in accordance with law without being influenced by any observations made by the learned single judge in the order dated. And it is made clear that this court has not expressed any opinion on the merits of the demolition order or the legality of it. We can proceed.
You should. Yes. Stephen,
That's
is an issue.
That's
This file is sent to her again.
That's
Because she is sign on the
that's
page. We're not wasting time. But this file should be sent to her
that's
for just before.
that's
Yes, 6 again, call 6. Yeah, yes, Mr.
Doordarshan employees preferred a way before the learned tribunal. Pursuant to orders passed by Karnataka High Court and the learned tribunal passed an order disposing of the matter with certain directions to be complied with within 3 months. The authorities failed to do it. We filed a contempt petition. The contempt petition remains pending for 8 months and continuously they don't appear. The authorities don't appear before the learned tribunal in spite of issuance of notice. Lord, I'll just show your lordship the orders passed by the
They will
learned.
direct the contempt to be heard out within a limited period.
My lord, and in the meantime, what they are doing is they are flouting the orders of the learned tribunal. I'll just show your lordship one line.
No, Mr. Samantha, we appreciate fully what you are saying, but we're not shutting you out also.
No, no.
But we'll record that they are subsequently flouting, and definitely Mr. Sevabalam will controvert that.
no notice has been given, my lord, they are not served the copy also. And says it is a matter of pertaining to ministry, may not be deep time to file reply. Otherwise,
What reply? We'll pass an innocuous order, we'll just direct the tribunal to decide the contempt application within a limited period. You are not affected in any way. And we'll say that you are controverting all allegations. And we'll also record in our order that you express your inability to file a report because of paucity of time. But we'll say we are deeming that you are controverting, not admitting any of the allegations. What is the contempt application number, MA number?
The CPL number. Lord, I'll give you that.
No, it's there in your prayer portion, Justice
Yes,
Dasde has
yes,
rightly
yes,
pointed out. Yes.
Yes. 127.
Exactly, we are thinking about exactly what you have prayed. So 8 weeks is a reasonable time. At the outset, learned counsel appearing for the you have instruction to appear for whom?
all this.
For the respondent submits that due to paucity of time and sufficient notice having not been given to the respondents, the respondents did not have the time to prepare a reply. So accordingly,
Yesterday only there.
it is clarified that only yesterday a copy of the writ petition was received by the respondents. Next para. However, learned counsel appearing for the petitioner submits that not only notice have been given in the matter to the respondents, the prayer made is limited, to the extent that the tribunal be directed to hear out a contempt application pending since long before the said tribunal. It is further argued, further submitted that despite the specific directions of the tribunal, the respondents have been flouting the same. It is further submitted that such deliberate violation of the directions of the tribunal is still continuing, giving rise to the urgency in moving the present writ petition. Next para, learned counsel appearing for the respondents, respondents controverts such allegations. Next para, since the prayer made in the writ petition is innocuous and we do not intend to touch upon the rights and contentions of the parties pending before the tribunal, the court is of the opinion that no direction for affidavit is necessary. It is, however, deemed that none of the allegations made in the writ petition are admitted by the respondents. Next para, in the light of the exigency pointed out by the petitioners, WPCT 23 of 2026 is disposed of by directing the Central Administrative Tribunal, Kolkata, within bracket, Circuit at Port Blair, bracket closed, to dispose of contempt petition number 127 of 2025, pending before it, as expeditiously as possible, positively within a period of 8 weeks from the date of communication of this order to the tribunal. Full stop. Next para. No orders to cause service.
And the time for next circuit is on 8.
Next circuit of the
No,
time.
but then VC can be done. They are doing VC. What is the problem? On one more thing, the bench will be comprised of, because what is happening, bench changes. But this bench, the order, original order is passed, page 57. The same bench should hear out the matter. Because what happens to
If you direct that, it will be impossible.
I know.
Then it will not be done within 8 weeks.
Yes, no. They will,
The two will be
they
contradictory.
will constitute a bench for that purpose. Like they do at 3 PM, fix and decide the matter.
Without giving unnecessary time, the circuit.
Will not put that in our order, Mr. Shamant. That will frustrate the direction of it.
No, then only one thing, and they have not entered appearance. Let them file their affidavit in opposition or compliance within this time.
A copy of the petition.
I'll serve a copy today. It's there in the entire petition.
Since a copy of the contempt application is annexed to the writ petition itself, comma, the respondent shall file their
Response, affidavit in opposition or compliance.
please
I'm sorry.
file their response thereto and stroke or affidavit of compliance in respect of the same before the tribunal.
Next date is 5/7. Next date is given. I'll
By 6 weeks from date with an advance copy, by 4 weeks from date, comma, with an advance copy to the learned advocate and record for the petitioners before the tribunal.
Next month is.
Next day is 7th May. 7th May is the date.
Within 4 weeks. We have given you 4 weeks. Do it within 1 week. If you are closing, then do it within 1 week.
And
You are there.
in the meantime, we are putting your verses. They should have one more line, right? In the meantime, let them not do anything.
No,
What is that?
no. That is entering. It is right. That will be entering the merit of offence.
Lord, the word peremptory your lordship has used, Lord.
No, positively you have used. But you are, sorry, we are modifying that. You asked for preferably. Only P is common in all three. Yes.
I had to come because of this matter. But
No, this is a pretext for you.
I mean,
No, you have other matters also. You saw on the last. Yes. Next. 7.
Milord, I am for UGC. Milord, my
Milord, in this-
video is not working.
My lord, I am appearing for the petitioner, your lordship.
Achha.
In this matter, my lord, UGC has already.
Ms. Ghoshal, we can hear you, no difficulty. Yes.
Yes, my lord.
Deeply obliged.
You're saying something. Yes.
Yes, my lord, in this matter, UGC has already filed their reply. I did not to give any rebuttal thereof. But so far as Mr. Rakesh has filed the affidavit that was served on 16, your lordship. But I said I'm appearing from the principal bench. I received yesterday. It is the longest affidavit, my lord, 102 paragraphs. I need proper reply, my lord, and let the matter be placed next circuit, my lord, because I constrained to do so due to paucity of time, your lordship.
You are for the petitioner?
I am for the petitioner and applicant before the learned tribunal, my lord.
Very good. So you want how much time? You say?
2 weeks would be suffice, my lord.
Well, on the prayer of learned counsel for the petitioner, comma, the time for filing reply to the opposition used by the respondent numbers 3, 4, 5, and 6 is extended for a fortnight from date. Full stop. Next para. Let the matter be listed before the next circuit for hearing.
Deeply
Deeply
obliged.
obliged, Milord.
Next. একটা একটু নিন না, এটা নিন। Section, এটা। Eight and 9 together. 8 and 9.
And the list of dates.
Long matters, Mr. Kumar, if you could take us.
Very short matter, within 5 minutes, I can explain the gist of the case.
My lord, if.
You will explain, but we won't understand in 5 minutes.
My lord, the issue is, my lord, practically, they have filed an appeal in an issue which is no more
Recently.
between the parties at least. Now, my lord, what happened? Vacancy notice was published with regard to several posts, including the post of postgraduate teacher. Now, my lord, my candidature was rejected on the premises I am overage. Now, my lord, administration has issued a notification whereby the administration says if a person worked under the administration on contract basis, such period will be treated and it will be expunged, my lord, so far as age part is concerned, my lord, it will be treated into account. Now, my lord, this was not done by the administration. They negated my claim only on the ground that I am overage, and I have not been given the benefit of this said circular of the
So
administration.
the contractual period will be added to your age.
My lord, because
The effect will be that.
Yes, yes, absolutely, my lord.
Show us that provision, Mr.
Yes, my lord. That is page 126, my lord. And tribunal has accepted this argument, and this point was not challenged.
126 of 6, WPCT 6 or 7.
My petition, my lord.
Yours is 8.
Eight, my lord.
Oh, sorry, 16. 8.
My lord.
8, 10. Correct page. 16 who is appealing? Oh, 16 is your counter.
My lord, this argument was accepted by the tribunal. They have not challenged. So that is not challenged, my lord. They have accepted it. That I am entitled for age limit.
But their challenge is against what?
Their challenge is that apart from this, one more prayer was there because they said that since I was a part-time employee, for every successive month for discharging the duties on contract basis, I am entitled for only 0.1 mark and not 0.2. Now, my lord, last occasion this court asked if 0.1 is also taken, whether I am true or not. They filed a complaint saying that he is true.
So page 126.
126. 19th September, my lord. Relaxation of upper age. Reference is the matter regarding extension of similar age relaxation to daily debtors so and so, including those appointed on Sarva Shiksha who have been working as such prolonged so and so. It has been brought to the notice of administration, although the above category of employee were well within their age at the time of their initial employment.
No, what's it?
There in the third paragraph.
Yes, sir.
They were within the age at the time of their initial engagement. However, over a period of time, they got overage, so and so. The para 4 method. It says it has therefore been decided that all such candidates would be eligible to be considered for age relaxation, subject to the actual period spent as SST ad hoc contract for working in the department to which they are applying. However, in the case of DRM, so and so, so when not working for the department, they are applying. I applied for postgraduate teacher, my lord.
No, you are working for the department.
Yes, my lord.
So, but here it says that, however, in case of DRM, so the total period spent in each of the departments shall be counted.
So, my lord, if a DRM is working in different department, the entire period will be counted for those DRM workers.
Let us just see this.
Yes.
Our apprehension was right that we may not understand it.
No, my lord.
Let us just understand this English. Yes. সেটা নিশ্চয়ই ছিল। দেখো ভয়বার দেখে নিন।
This court accepted that I am entitled. Subsequent to this, the administration, on the basis of several other cases, my lord, even I have done some cases earlier, the administration themselves issued a circular saying that all of them are entitled on 18th December.
So, what is your grievance then?
My grievance is that, my lord, the tribunal arrived to a definite finding that the age limit will come. At the very inception, when I moved the original application, tribunal passed an interim order saying that it should be avoided by the result. But the tribunal, in the last paragraph, the tribunal said if the post is lying vacant. So the very purpose of approaching the tribunal, the interim order, everything goes. And my lord, this court on 3 occasions, my lord, passed order whereby this court was convinced, my lord, that I am entitled. Once the tribunal arrived to a finding that it is their mistake because of which my candidature was not considered and I stood at serial number 1, then I am entitled, my lord.
You are already working in a post.
No, I am not working, my lord. I was working on contract basis. That period was not treated by them to give me age relaxation.
You reached your superannuation age during that contractual period itself.
No, my lord.
I don't understand.
I applied for the said post, my lord. I was aged about 36 years
Yes.
when I applied for the regular post,
Then you were already doing contractual work.
contractual work. So that period they have not counted, my lord.
On the date of your
relaxation.
on the date of your application, you were already over age.
For age. So that if that circular is taken into account, I am aged. Tribunal arrived to a definite finding that circular is applicable to me.
Understood. Bishop Kumar, one thing, if there is actually no vacancy, then
No, my lord, because there was an interim order. This court on 3 occasions.
you are permitted to. What was the
interim order? The
interim?
court says, my lord, can you come to page?
Interim order of this court or the tribunal?
Tribunal, my lord, page 161. I will show 2-3 documents.
Abide by result that.
Yes, yes.
But what are you permitted to do? Consider, whatever.
Yes. If my lord sees, considering the ground by way of an interim bill, it is directed that the selection process shall abide by the outcome of this POA. The said interim arrangement will continue till the next date of hearing.
So the selection process was going on.
Moving on at that point of time. Now, my lord, I will show the offer of appointment to that candidate. Now, my lord, can you see the offer of appointment at page 185? And thereafter, administration's affidavit, page 185.
There is only one post.
One post, my lord.
What can be done then? That person will be.
No, but my lord, that's why that person was added as a party. And this court directed, my lord, at the first inception to the Union of India, you create a post because the court was convinced that order is also there. You create a post because, my lord, I was not at fault. I approached the court in time. There was an interim order. Now, my lord, can you see page 185? This is after that interim order. 29th November 2025. This is offer of appointment. Now, my lord, can you come to page 186 from paragraph number 24?
Oh, yes.
Now, my lord, his acceptance letter is of 50. Next page, my lord. Now, I will show only their opposition at page. Administration filed a opposition that replied before the tribunal. Relevant would be para 10, page 170. It starts from page 165, paragraph number 10. In this regard, it is submitted that since there was no stay order of any court on the post of so and so, as said, the offer of appointment to the monthly post of so and so was already issued to the department, to the eligible candidate, and the selected candidates are also tender acceptance of the same as on date has already been exhausted. No more post from the said so and so, so and so. The above recruitment was concluded on so and so. Now, my lord, despite of it, my lord, they have contested before the tribunal. They say there is no stay order. Now, my lord, may see 3 orders of this court, my lord, this court in this proceeding. My lord, may kindly come to the order dated 17th March 2025 passed by this court, my lord. This is the first order, my lord, of 25. Third paragraph, my lord.
17th March.
17th March 2025.
You order.
Passed by my lord Justice Suman Sen and my lord Justice Shahrukh Basu.
আগের order গুলো কোথায়? Stephen? এটা তো previous order. ও আচ্ছা, it's in full. Sorry. Yes. Yes.
Now, my lord, court says
the administration shall file an affidavit limited to the issue as to whether the petition can be considered to be qualified in terms of circular dated so and so. In the event it is found that the petitioner is qualified on the basis of the said circular read with para 10 of the impugned order, then having regard to the nature of interim order exists during the pendency of the original application in favor of the writ petitioner, the Union of India may have to create the post or to make suitable adjustment to accommodate the petitioner. Now, my lord, the matter shall be listed. Now, my lord, may kindly see order dated 19th of February 2026 presided over by my lord Justice Devans Prasad. Second paragraph.
February?
February 19th February.
Yes, second paragraph.
It says being agreed in the original proceeding before the tribunal, an interim order was passed directing the selection process avoid by the outcome. Such interim order was passed on 29th, that is 27th, my lord, 27th of November 2023. Material disclosures demonstrate that the participants were evaluated, mark awarded, accepting the petitioner and another person who were found to be overrated. Petitioner is entitled to a just consideration of his candidature in the selection process, wholly without prejudice to the right of so and so, accordance with law, and award the marks so that so far as the petitioner is concerned. Now, my lord, after this order, my lord, will kindly see order dated 24th of February. Second paragraph.
Yes.
It says, it appears, because my lord, they were asked to file an affidavit. It appears that the mark obtained by the petitioner is higher than the person who was appointed in this post. In the original, before there was an interim order, there is also interim. In the factual matrix as noted above, it would be appropriate to hear the person, because my lord, so far as the issue with regard to.
So you served a copy of the evidence?
Yes, my lord, and I filed an affidavit of service.
But she's not appearing.
No. So, my lord, my contention is that, my lord, may kindly visualize the situation. I was not at fault.
He has received.
My lord, I have filed an affidavit because this speed post I have sent, he has received.
Received?
Yes, received is there, my lord.
Mr. Kumar. Mr. Kumar, you just check up whether he has received.
I have seen it, my lord. Item delivered, my lord. Item received, my lord. Item delivered, it's so. Because he's posted in under them, their school letter under, my lord.
Right.
It is only written item delivered, my lord.
Right.
If, my lord, they want, they can give a notice and let him come on Tuesday, my lord, on Monday or any day, my lord. Because this was service was affected, my lord, it was given. And he is working under them in Rangat school, my lord, under the authority administration. Now, my lord, my case is, my lord, I was covered under the said circular of Andaman Nicobar administration dated 19th September 2011. It was the fault on the part of the administration that they did not consider my candidature on the said. I worked more than 5 years under them as lecturer, as teacher under the education department. Now, my lord, thereafter an interim order was passed on 27th of November 2023 by the tribunal that everything is abide by the. Despite of existence of an interim order, an offer of appointment was issued on 29th of September. And there is a specific condition that your appointment is abide by the result. He accepted it from the record, it reveals that on 15th of December. His appointment order they have not enclosed, my lord, but his acceptance is there. Appointment order they have not filed along with the opposition. Now in the opposition, my lord, they say, my lord, at para 10 that there is no stay order from any court.
Yes, let us hear this.
Yes.
Yes. Yes, Mr.
That will be filed by the the factual aspect. I have verified my list of dates. Now we see we have frequency held.
0.1 doesn't make a difference.
Yes, because that court is directed us to file a complaint. That extent we have filed now. Because what is on record?
So what is your answer to this?
Because the offer of movement we mentioned that all of the
Yes. You fairly mentioned and he also accepted.
both the OAs are pending or not pending. Any other OA subject to this.
What about creation of a new post of what is the post?
Postgraduate PGT Bengali.
So isn't there any necessity for PGT teacher anywhere else? Only one PGT teacher?
As per the available SAC system required that has been.
No, that has to ascertain only one post was published. It is not that throughout the island only one post is required.
ascertain the vacancy position today. We'll keep it tomorrow. Over the phone, at least ascertain and tell us, apprise us. Is honest.
Only on this point.
Let it be on Friday, my lord. Monday, my lord, then they will be.
Today is Thursday.
Thursday.
Tomorrow, my lord. Only my letter has to take inspection, my
The
lord.
roosters has to be checked.
No,
They want, they can do it within 24 hours if they don't want.
he will do it immediately, but they go by Indian standard time.
But with regard to the,
Circle, whether it is retrospective or prospective, that they have taken. They are strictly thinking different. They are saying that is not regular prospective. I am trying to the circular. Telling of the circle is little different. If you have the doing here, so that it exists.
Retrospective.
Question of doesn't arise.
We have also were indicating to you, Mr. Kumar, as rightly pointed out by the bench partner, that you have taken a point of retrospectivity. This is not retrospective. The operation is not retrospective. They were working already, and because in paragraph 32 you have stated that declared that the is not entitled to retrospective application of that circular.
this being passed, because the actual case is that one septic area has approached initially. Because not as per the circular, those who are working as a guest lecturer under the JNRM college are not entitled to granting to any age. So those who are working under the education department, those who are working under various other departments as a DRM or contractual, they have been granted with the age relaxation. But they are not working under guest lecture under the colleges. JNRM college, Mahatma Gandhi college. So they are not been considered. So they approach before the tribunal. Secretary on she has approached. This court has said, tribunal has said, no, as a guest lecturer, it should be as also a part-time working. So they have to be considered in terms of this level circle. After the judgment passed by the tribunal, the authorities are fairly issued a circular saying that even the persons who are working as a guest lecturer also, they will also be considered. So far as
This is a question of retrospectivity.
but not the circular has come on.
No, the subsequent circular clarified is only
Yes,
clarified.
yes,
It only clarifies the previous.
It's not clarified by the tribunal. So that is,
So we'll not hear you on that point.
but with regard to
Time passed. Only
Subsequent circular is clarified. It is clarified.
with regard to the 0.2 not,
0.2, 0.1, you don't have any other score.
but this is been held by the court that.
You have filed a complaints report. Now we won't hear.
Not me, I'm saying, I have filed the challenging the part of 0.2 marks to be awarded to the part-time basis. In order to see the vacancy notice, it is 0.1, it is clearly specified. Even the tribunal has said they are, but I know if 0.1 or 0.2, then they will, because it's entirely in 0.1 also, because I have filed a complaint in terms of the court, that I calculated the marks I produced. But my humble submission was 0.2 more than it will be created. Following here future, that is why humble. Not the earlier on the litigation also the control tribunal has issues that feel with regard to the.
No. That there it was not the subject matter. My lord,
My lord, this is honorable is modified by
this.
So we'll keep it on Monday. The scope of the two writ petitions have been filed respectively by the by one Sri Pratap Chakraborty and the authorities. So next para, the limited scope of challenge in the application filed by the aforesaid individual is that the learned tribunal, while holding in favor of the petitioner on the strength of a circular dated September 19, 2011, issued by the A&N administration, granting age relaxation subject to the actual period spent as SSCT/ad hoc/ contract for working in the department to which they are applying, and issuing directions in favor of the petitioner, added a rider that such relief shall be subject to the available vacancy. Learned counsel for the petitioner in WPCT 8 of 2025 argues that the same would be contradictory with the main relief granted to the petitioner, moreover, by an interim order dated November 27, 2023, the tribunal had permitted the fresh selection process to continue, but clearly observed that the same would abide by the outcome of the original application of the petitioner. Whose next para, Learned Counsel further points out that despite the same the administration proceeded to issue an offer letter, vide memorandum dated November 29, 2023, to a new incumbent, in which, clause 24 categorically mentioned that the outcome of any case pending with the tribunal and this court pertaining to recruitment to the post would affect such engagement. In his acceptance of the offer of appointment, the new incumbent categorically expressed his willingness to accept the said offer of appointment as it is. Next para, even thereafter, pursuant to an order of this court of a coordinate bench, the petitioner had impleaded the new incumbent and has already served a copy of the petition on the added respondent, who served despite the same the said added respondent is not represented today. Next para, it is contended that several coordinate benches, while taking up the matter, have expressed the opinion that if necessary, a new post should be created or an accommodation to be made for the petitioner, in view of the tribunal's order, judgment having gone in favor of the petitioner, particularly in the teeth of the nature of interim order, which clarified that the subsequent selection process would abide subsequent category. The selection process will abide by the outcome of the original application. Next para, since an impasse has arisen as to the actual vacancy position for the concerned post of postgraduate teacher Bengali language in the islands, in a post commensurate with that which is the subject matter of the present challenge, Learned Counsel for the administration is requested to take instruction as to whether any equivalent post is vacant at present in the islands, in order to enable the court to make appropriate provisions in the final order to be passed in the present petition. For such limited purpose, the matter is adjourned for the day, adjourned and shall next be listed on April 27, 2026, when it will be taken up prior to other matters at the top of the list. It is made clear that other questions, particularly in the writ petition preferred by the administration, are kept open for being decided at the final.
The interim order was dated 29th November, wrongly said. In the list of dates,
November 27, I have 6, November 27,
page 160.
November 29.
Right.
Thank you.
You can reduce so much culture. You can reduce so much.
Yes. Just can you just please switch the microphone on? 81. What is the reason for the delay?
The reason but in the procedure requires.
Affidavit in opposition to section 5, why? Who has instructed? What is the reason given, Ms. Das?
The procedural requirements of the department.
The respondent does not want it to happen before this bench. So let them use an app. It's obvious. Yes, but this will be the first ground if they challenge subsequently. If we allow without granting them that opportunity, so you will be, even if you get a favorable order, it won't help you. The respondent seeks to use an affidavit in opposition to the condemnation application. Accordingly, the respondent is directed to file such opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Let the matter be listed before the appropriate bench in the next hearing. Thank you.
Here, this petitioner was engaged as a sweeper on daily rated basis under the Portland Municipal Council, my lord, on 6th of June 2013. And he worked up to 27th of December 2022. Thereafter, my lord, he had certain health issues for which about 8 to 9 months he did not join. And he has informed his superior and
You
his
walked up to which date?
my lord, 27th December
27th.
27th December 2022. So more or less he has worked for 10 years.
Contractual.
Daily rated.
Daily.
Daily rated under the Blair Municipal Council.
Yes, yes.
Now, my lord, he was ailing from ill health. He had some ailment, my lord, that documents and all he placed when he reported duty. He was absent from duty on and from 28th of December 2022 to 8th of September 2023. Near about 9 months, my lord. And he has informed them and he reported duty along with medical document, fitness certificate and all. He was not allowed to join. When he was not allowed to join, my lord, by that time the administration has promulgated.
Alternative remedy on the ground of alternative remedy.
No, two things are there, my lord.
Argue only on that.
No, two things are there. My lord, this period, my lord, as my lord has.
Mr. Kumar, even if you satisfy us on the merits, we cannot take up, should not take up on merits, because that will be taking away one appellate jurisdiction for both of you. We have to relegate it to the writ court if we hold in your favor by saying that no, still you do it.
Yes, still I will just confine my argument to that. Now, my lord is aware of that circular issued by the government of Andaman Nicobar administration on 22nd of September 2017, whereby it says that irrespective of the fact if a person is entitled for 1/30th of pay, irrespective of the fact whether post exists or not. Now, my lord, admittedly, it is an admitted case of them that I worked up to 27th of December 2022. Now, this circular came into existence on and from 1st September 2017. So, my lord, the difference of pay for the said period I am admittedly entitled. There is no dispute about that. So that payment was not made. So I filed a writ petition on two grounds. My lord, I had another writ petition wherein the London single judge has allowed it. And my lord, I cited the judgment of this single bench, division bench, and Supreme Court, which was not interfered by the Supreme Court. My lord, a person worked in a post, he was paid lesser payment, and by a circular administration decided to give them higher scale. Then definitely for the period for which I worked, I am entitled. Now, my lord, can you see?
You want that 1/30th, that pay.
That period, my lord, that period I am entitled, and that period up to which I work is an admitted case of the authority that I work. They themselves say.
Mr. Kumar, on merits, what is your submission? Because he's a sweeper. I mean, these are marginalized people. So if you agree on principle, then we can allow it from here.
He says he is having some medical problems, but when he should intimate the authorities prior to leaving the office, on fine day he has left the office. He has been discontinued, not because the roster has to be maintained. He is not in the roster where I think he wants the date.
But
Yes,
you
not
cannot say
intimated.
unauthorized absence because he was not a regular.
Yes, I have been indicated that I'm going for medical treatment.
So is
Yes,
it a
not-
penalty? Can you do that? Then otherwise he's entitled in law for the
Yes,
period he worked.
8th September. First time when he has come, that is on 8th September.
No,
And-
we are not bothered with the rest of the period for the subsequent. After 8th September, he again joined.
Only after 8th September, he come with 2 medical certificates.
So you did not take him.
We are not, because the roster is already.
We are not asking you to take him also. But for the period he worked, he's entitled as per your circular. Pay him.
I think continue to working on that. Because it is
Show us that circular just there.
continue working.
Only show us that portion, Mr. Kumar, Mr. Rakesh Kumar.
Good.
Page. Mr. Vinu Kumar, please.
Yes, my lord. My lord, may kindly see page 43 of the paper.
Yeah.
This is the information furnished under Right to Information Act, saying that only those persons who are continuously working. Now,
Page 43.
43 is the reply to RTI, my lord. 43,
We have been continuously working with it.
yes. So this is what they are saying, my lord.
But where is the circular?
Circular.
No, by dint of which you are.
No, my lord, may just once come to page 44, my lord, their reply. I'm just placing their reply, what they are saying. So they are saying that, so and so, upon second paragraph, thorough review of the court order, it has come to our attention that the order explained mentions the granting of areas to PR who have been continuously working within the council and were granted the status of. However, there is no specific mentioning of extending areas payment to daily rated Mazdoor who were discontinued, terminated for the set period in the court order. So they said that it is not specifically mentioned. My lord, what happened? I filed a writ petition before this court in respect of 126 persons. Another, same, they are daily rated employees. When the writ we succeeded, they removed 27 persons from the post when the matter was pending before the division bench. Now, my lord, subsequently, they were given the payment. Those all documents I have enclosed, my lord. No, the ground, the paramount ground which has been urged that must be, my lord, this payment is pertaining to the period for which he has served.
This request a bit hearing. Let us see on maintainability before the court. Whether the learned single judge was right in saying that you should go for the appropriate hearing.
So, as far as this payment part is concerned, my lord, this is an admitted fact that
There's an application for condemnation of delay.
my lord, 20 days delay is there. I am just.
22 days.
22 days.
Delay we are allowing in view of Stephen. In view of sufficient, you can take down from there. You can sit there and take. You can sit and take the order.
No.
In view of sufficient explanation for the delay having been given, can 1 of 2026 is allowed on contest, thereby condemning the delay in preferring MET 73 of 2026. Which next part of the order, your person.
My lord,
Take it.
my lord, we once see page 84, my lord.
No, just we'll see the
Yes.
in order once. Why the judge says that.
Only one paragraph, page 145. All the judgments were cited and they are to last paragraph on overall consideration of.
But why does the learned single judge say that you should go for the
My lord, so far as second part, my lord, the reinstatement altogether different aspect, it could be. But so far as the fact which is admitted by them at page 84, saying that I have worked, if I have worked, if certain payment is balanced, I am ready to, I am entitled to get it, my lord. Under no circular, no law.
But yes, lead court should have heard it, Mr. Kumar. You are shirking out duty if you do these things.
No. Let me not clarify. My lord, before my lender friend clarify, my lord, once see page 84, thereafter, whether my lender friend can make this argument, I have discharge duty, certain areas are there, you have to pay, you are under legal obligation. Being a state authority, you must pay, page 84, my lord. This is their affidavit. They say that I worked up to 29, page 84, para number 7.
Let us see the case you made out before the lead court.
My lord.
Whether you asked for that.
Yes, my lord. Yes, my lord.
Show us that portion.
Yes. In the judgment or in the writ petition?
In the judgment. Your case has been. Yes, writ petitions, many things are written. You may not argue that. 50.
If my lord sees, second paragraph itself, my lord, I say, the court itself take note that in terms of the circular, this is my case which I have made before the single.
Yes, Mr. Kumar will relegate it to the writ court. Court should have heard this. Yes.
Lord, the order establishing the contractual trade was granted to courts versus not exposure page.
Paragraph number of the judgment?
Page number 45, yeah.
Page 45. No, on the merits, we are not going into the merits. We won't go into the merits, Mr. Kumar, because that would, as we said, that it is for the writ court to do it. Otherwise, both of you will. Everything will be kept open. We cannot touch the issue merits. If you touch the merits, we'll decide it. Writ court itself has only not gone into the merits, relegated them to the alternative forum. But we are of the opinion that this component about this, according to the benefit of the policy decision, they are 1/3. That at least they could have agitated before it.
That may be indicated.
Have to.
We got to deed statement or
The ambit of the present appeal, is limited to serve as such, we take up the appeal itself for disposal at the admission stage upon notifying learned counsel for both the parties. Next para. By the impugned order, the learned single judge relegated the appellant to the appropriate forum, clause, for praying the reliefs as sought in the writ petition on the ground of availability of alternative remedy. To sub next para, learned counsel for the petitioner argues that it will be evident from the very second paragraph of the impugned judgment that the writ petitioner stroke appellant had prayed for a direction on the respondent authorities to accord the benefit of the policy decision taken by the A&N administration, vide Office Memorandum dated September 22, 2017, by according the benefit of 1/30th of pay plus dearness allowances to the petitioner stroke appellant on and from 1st September 2017 to 27th December 2022, with interest for discharging the duties and responsibilities of regular employee for 8 hours a day. Although a prayer for regularization was also made, learned counsel submits that the writ court had ample jurisdiction to direct the respondent authorities to comply with their own office memorandum and grant the benefit as sought to the petitioner. Next para. Learned counsel appealing for the respondent authorities submits that in view of the stress of the prayers made by the writ petitioner being on the regularization aspect of the matter, the writ court was justified in relegating the matter to the appropriate forum. So next para, although learned counsel for both sides seek to argue on the merits of the case, comma, we deliberately do not take note of the same, comma, since if you do so, comma, it would prejudice the writ court, comma, in view of the order which we propose to pass. So next para, upon a careful perusal of the materials before us and the recordings of arguments in the impugned order itself, comma, this court is convinced that the writ court, comma, under the prerogative writ jurisdiction under Article 226 of the Constitution of India, comma, had ample power to redress the remedies sought by the writ petitioner, comma, particularly in view of the fact that since the writ petitioner stroke appellant comes from the marginalized sections of society, comma, having worked on ad hoc in the capacity of DRM as a sweeper with the Port Blair Municipal Authority, Municipal Council, comma, he ought not to have been relegated to a further litigation. Accordingly, on such limited point, comma, the MAT 73 of 2026 is allowed, comma, thereby setting aside the impugned judgment dated December 19, 2025, passed in WPA 652 of 2024, and relegating and remanding the matter to the writ court for an adjudication of the merits of the prayers made by the appellant, comma, in particular the prayer regarding according the benefit of the policy decision Vide Office Memorandum dated September 22, 2017 with regard to 1/30th of pay plus dearness allowances to the petitioner stroke appellant. Next para. We, comma, however, comma, make it abundantly clear that we have not entered into the merits of the respective contentions of the parties at all, and it will be open to the learned single judge taking up the writ application to decide all issues between the parties independently and in accordance with law. No orders to cause circumstance. We have kept it vague.
I have not said that. I have not asked for.
No, we have said particularly in respect of that. We could consider with it. Oh, regularization wherever stated, reinstatement. Writ court is not absolutely powerless. Yes, thank you. Can two of such and such is also disposed of consequentially. One আগে হয়ে গেছে, two টা এখন বললাম, শেষ হয়ে গেল, পরে মেরোটা। Yes. আপনি চারটে করে রসগোল্লা খাচ্ছেন আমি প্রেশার থাকে সত্ত্বেও আমি দেখছি আপনার ব্যবস্থা নিচ্ছি জানো তুমি তারপর থেকে রসগোল্লা খুব সুগার আছে ধরে একদিন মার দিতে হবে বেরোনো শোর পরে আর sorry, yes.
Sir, this is an appeal against the Labor Tribunal Award.
I received a copy of the objection.
Use the microphone. You're already soft spoken and you're all.
Senior advocate Vikas Merchant is appealing your lordship.
We will never get him. He's busy in other places.
Yes, so I pray your lordship, the matter is put to the next appeal.
Can it is for limited?
I am not.
We'll record that senior advocate Mr. Vikas Bhattacharya has a problem with this bench and therefore. What is the difficulty?
This only this matter has been given to me, your lordship. When advocate recording the read code, I received a copy, your lordship.
Oh, achha, right. Because you have to intimate your client.
Delay of 25 days can control. Can there be disposal?
I am not in position to say anything.
On the pair of learned counsel appealing for the respondents, which respondents?
All.
Respondents, comma, let them understand adjourned till the next session.
All right.
ওদের চলে আসছে তোমরা রেডি থেকো পরে ম্যাটারটা নিয়ে উঠবো। After 13 we'll rise because we are in any event to rise at 12. We won't take up hearing matters. 13 টা কল করুন। You're for the petitioner. Learned counsel for the petition, learned counsel for the appellant, sorry. Learned counsel for the appellant submits that the private respondents have not yet been served. So accordingly, on the prayer of the appellant, let the matter stand adjourned till the next hearing.
But if they will take one or the application. Yeah, the enforcement of the award. Paperwork has been filed.
Section 36.
Yes, 36.
You're for the other side.
No, madam.
I was researching for today.
Hearing matter, Mr. Dikuzbi Gaurav.
Actually, I want to make the submission with regard to intent.
14 and 26.
My lord.
14 then well, 14 Mr. Dikus, there is no can.
It's no can, but in the.
There is an addendum prayer in the petition. But they will have to hear it on merits.
My lord, very sure. My landed friend's original application was dismissed on the ground of delay and on merit. Now, my lord, my landed friend has challenged a seniority list of 2016 and he wants stay of that. I will make submission because there is no delay. There's no delay.
Mr. Dikus, normal course. No, no problem. And your 26, what is 26?
The award.
Enforcement of the order, in any event, you have to serve notice on the other side.
Yeah, okay.
So then it will amount to full hearing. Section 36, if you want stay, it means full hearing, just like section 34.
My lord, they have not deposited the amount. The award was passed in the year 2007, my lord. And till date,
2007?
yes, my lord. And they have not deposited the amount yet, my lord.
That is why he is asking for stay.
My lord, but then in that case, my lord,
No
34
preference. 2007 award, no preference. No. No preference.
my lord.
No.
Grateful.
Yeah, parent due. We'll assemble after say 10-15 minutes for the singing.
Item number 47. The Lordship had heard this matter in trust and the Lordship had asked me to get the photocopies of the charge sheet. It's a case of washing. Wherein a actionable claim under law fraud has been visualized as criminal act.
Well, this will appear at the top. Tomorrow, inform the other side.
Right.
Tomorrow at the top.
Take care.
Stephen.
Well.
You should take. Tomorrow.
Any other question? Item one. Yes, it is one of the.
Hello, I am appearing for the petition, my lords, appellants.
Yes.
Actually, my lord, this records were not found as such, I have mentioned it. Now they issued a letter whereby they found the record.
The paperwork directions and all were given.
Yes, yes. So I will.
Good.
If
So-
necessary.
As rightly pointed out by the counsel for the appellants, the matter was mentioned since the records were not being placed, but it transpires from an office report dated April 22, 2026, that the records have since been placed out. Accordingly, there is no necessity to pass further orders to that end. Liberty is granted to the parties to mention the appeal, as and when the same is ready for hearing, for enlistment before the appropriate circuit. One to go. Hey, Stephen, board is not functioning.
No.
It's functioning in morning.
Somebody is going to defect minute, it's being done now.
Good. Next.
Lordship, I would like to mention something. I have to rush my
Yes.
school of my exam.
What mentioning?
But my matters may be taken up.
What matter? Which matter?
Lordship, item number.
If nobody appears, we'll pass it over. Just inform somebody to come.
Item number 6.
No, when it is called on. So you keep some, ask any of your junior friends to.
Miss, my senior will be.
Senior friend will. Just mention, we'll grant it.
It would be.
3. Yes.
Yes.
I appear for the petition. This matter was taken up yesterday and then a prosecutor has chosen to get the instructions.
Yes. Yes.
Now, Lord,
Stage of trial and all. Just
Yes.
remind me the facts, Mr.
it's a case of a circumstantial evidence. Wherein the accused person, there were 4 accused persons and they were arraigned as an accused for having committed an offence under section 103. Previously, it was section 302 of it. Now, in this case, prime accused already expired and they are in the judicial custody from 1st of April 2025. Till date, only one prosecution witness, that is PW1, has come, and for the last 7 months, no witnesses were there. For the several reasons, the court was not there, all these things. And in the prime charge sheet, there is around 84 witnesses, and in the supplementary charge sheet, around 14 witnesses are there. Not the accused persons, they are there in the judicial custody for last more than 1 year and 20 days. And that apart, the grounds of arrest ultimately has not at all been communicated to the accused person.
You are not the prime accused.
No, I'm not the prime. Prime accused already expired. Not here,
Prime accused is already
expired in
expired.
the judicial custody.
Investigation.
Not during investigation. After completion of investigation, not that apart, kindly see, after submission of the supplementary charge sheet, in the meantime, the IO is again filing 2-3 applications for further investigation, that is for the purpose of getting the photographs, for the purpose of getting the voice samples. Those applications are still pending and those processes are still going on.
So you are in custody for what period exactly?
1 year and 20 days, more than 1 year. And the grounds of arrest, yesterday I have shown this particular judgment of the Honorable Apex Court.
Not communicated.
Not at all communicated. That is an admitted fact and that cannot be denied us.
Yes.
Para 12, Shri S. Nagamuthu and Shri P.V. Dinesh Leonard Counsel, appearing for the appellant's place reliance on the judgment of this honorable court, that is Mihir Rajesh Shah, which is continuously being followed, and urge that failure to furnish grounds of arrest to an accused in writing amounts to violation of fundamental rights guaranteed under Article 21 and 22 of the Constitution of India.
Para 20 is the fine.
Yes, Lord. And thereafter para 13, Lord. Next para. The constitutional mandate of informing the arrestee the grounds of arrest is mandatory in all offences under the statute, including the offences of IPC, now BNS.
Yes, we have seen. Para
Yes,
12,
same.
13 and 20.
Yes, my Lord. Yesterday also based on same
Yes.
thing, the order was followed.
Let us hear, Mr. Yes, Mr. Konmakar. Yes.
Regarding grounds of arrest, this judgment is the latest on April 2020. And you are arrested on 2nd April 2012. Even in CRPC, grounds of arrest has to be given. That is serious. But adjudicating that violation of Article 21, that was discussed in this judgment. That is discussed in the judgment. But you are arrested on 2nd April 2025. Now, investigation agency following that judgment, that intimation grounds of arrest.
The charges against him were circumstantial. I mean, they.
Four accused person, names culprits, who was the hero of the incident.
Hero of the villain, whichever way you
Yes,
look at it.
accident, but conspired with these three accused persons, including one lady. One young reporter was badly assaulted by vehicle tools, that is heavy rod. Thereafter,
He was not present at the site.
present in the site. CCTV footage, digital evidence is there. CDR, SDR, everything. There is a corroboration. Main accused expired. Enmity between the main accused and the deceased. He enlisted these three persons, including one Vitigara. Two accused persons came from Chennai, Tamil Nadu.
Mr. Konmakar, the charge sheet has already been filed. Investigation
true.
cannot be influenced.
But see, always trial court also not that the investigation has been influenced. Further, chance of influence the witnesses concerned, that is very vital part.
One thing
During trial, influence of the witnesses is a very vital part. Not a fault for the fair investigation, only at this stage limited.
One thing can
But influence of the witnesses before the trial, because
We'll come back to you, Mr. Yes.
yes, seeing the gravity of the offense, 35 years old young reporter, badly assaulted, murdered. On the same day night, his body was taken to the farmhouse of the main accused. Excavator Hitachi machinery was issued to conceal the dead body. Arranged diesel, petrol, burn, enter night. He waited with these three accused persons. Only wristwatch was found during investigation. Dead body entirely burned. It is not a simple case of murder 302. Serious allegations.
Let us hear. Yes.
May I say something here? I am only on the basis of the law, but it is mandatory on the part of the prosecution, on the part of the IO, to issue the grounds of arrest, irrespective of any kind of offences. It is not the gravity of offence that is supposed to be decided over here. Lord, kindly see, altogether there are 90 witnesses in this main charge sheet. And out during this 1 year, only
Mr.
one.
Ilango, you yourself admitted that there are still applications pending for reinvestigation.
Yes,
So
no,
wouldn't it be risky to?
Miller, one thing, no, Miller, kindly see, the evidence has already been started.
That's
Evidence
true,
is started.
but further
Evidence is
investigation applications are pending. It
No,
will be a
no,
bit
right.
risky.
Right.
You will not take custody for so. I mean, you are in custody for more than 1 year.
90 witnesses.
Great.
And grounds of arrest, Miller, we have
No,
to.
you can renew your prayer later, but the gravity is too much.
Miller, kindly see, Miller.
We can't take a risk of the
Miller, one
witnesses.
thing can be done. The grounds of arrest, it is mandatory by the Honorable Apex Court, which has stated that
No doubt.
in the event of non-failure, the subsequent, Miller, kindly come to 66.4, Miller, page number para 30. Miller, kindly see.
Yes.
In case of non-compliance of the above, the arrest and subsequent remand would be rendered illegally and the person will have to be set free. Now, this is mandatory. One cannot overlook it because this thing was followed following the judgment of Mihir Rajesh Shah. This thing was followed. And it is an admitted fact that the written grounds of arrest was not at all communicated to the accused persons. It was not communicated.
No, Mr. Elango, we are refusing. We are giving our reasons. We're giving our reasons.
In that event, Milord, I may be allowed to
Renew.
renew my prayer, allowed to withdraw with the liberty to file it before the trial court.
But
That liberty can be given, Milord.
But we'll record the arguments. Without that, we cannot. Now, because
But-
after arguments, you are asking for that relief.
I may be allowed to.
We'll permit you to withdraw, but we'll record our reasons.
Milord, I may be allowed to file the same.
After
before the
hearing,
trial court.
after the court expressing its mind, if you want to withdraw,
Milord, but because there is a grounds of arrest is there, Milord, kindly see. That thing has to be seen.
we're seeing everything. But if after we
Milord,
expressed our mind, you are
No,
asking
Milord,
for this,
one thing.
we'll
Milord,
have
if
to
at all-
record everything and then say at
I
this
got
stage.
it, Milord, kindly-
That would influence the.
No, kindly hear me first. Thing is that, my attendance can always be secondary. My lord is of the opinion, because kindly see what are the applications filed by the concerned IU. The IU has moved an application for two things. One is for recording the voice samples of whom? Of the accused persons who are there in the judicial custody. Secondly, they want the photographs of whom? For the accused persons who are there in the judicial custody. Not only this thing. Otherwise, all other things have already been completed, Milord. Only for the purpose of obtaining my photograph, Milord. It is not that they wanted to collect some other evidence which they have not collected. Because the charge sheet was filed in the month of April, Milord. And my attendance can be secured if the state is having an apprehension, Milord. Then I can be directed not to enter into PS Diglipur area. I may be allowed to stay here at PS Port Blair at PS Aberdeen.
Your residence is in Port Blair.
I am not a resident of Diglipur. I will stay here, Milord. I will stay here. Daily, every day I will go and put my signature, Milord. Kindly visualize the situation. 1 year, 20 days, Milord, I am there. Milord, conditions can always be imposed. Because so far as these two applications are concerned.
All the witnesses are of Diglipur.
All the witnesses are of Diglipur. I will stay here, Milord. At Port Blair, I will
Yes,
stay.
Mr. Korma, what do you say to this?
I will stay here at Port Blair.
I will definitely oppose.
No,
So
oppose, obviously, you
Seeing
cannot
the gravity of
Milord, gravity, I understand.
seeing
Milord.
the gravity.
Milord, I will have to be given a fair opportunity. If I am granted an interim bail asking me directly to go and report to concerned PS Aberdeen, no prejudice will be caused. The question of going and influencing the witness at Diglipur will not arise. This is very clear, Milord. I will be here. I will be here at Port Blair, Milord. And I am daily going to report. Milord, the purpose will not be defeated. Because after 1 year, if I am still allowed made to remain there, there will be no purpose solved.
Is it correct, Mr. Kormakar, that the applications pending are for recording voice samples and
Yes,
photographs?
I'm placing.
Do you dispute that?
Yes. No, I'm placing.
No, he's agree. Yes.
Photographs, that part.
Only the photographs and the voice samples are mine.
No. You are agreeing to that part. That the applications are only for
But
that.
I couldn't find from the case diary at this stage. I cannot.
Because, Milord, I am placing it. I will not
Because
I will not misguide
I
the court
cannot
for
say
getting
that
an
I am
order.
confirmed, but so I cannot submit that part because trial record.
And Milord, this was filed at a very later stage. My voice samples can always be taken. I am ready and willing to cooperate with the authorities to give my voice samples and the photographs. I will remain in Port Blair.
Photograph we do not find here.
Milord, that is also there. I am placing it. I am having the order sheets.
Voice conversation, yes. This speaks only about voice conversation.
Here it is. Milord, look at this. This is the prayer of. This is the certified copy of the petition.
Well. We're granting bill on that stringent condition.
I'm ready.
The present petitioner is one of the co-accused in a charge, inter alia, of murder. Full stop. Next para. Learned counsel for the petitioner contends that there are 84 witnesses mentioned in the charge sheet, as well as 14 in the supplementary charge sheet, comma, out of whom only one witness has been examined till date. Full stop. That apart, comma, for the last 7 months, comma, due to various reasons, comma, no prosecution witness could be examined in the trial. Full stop. Next para. It is submitted that the petitioner is already in custody for 1 year, 20 days and is not one of the prime accused. Full stop. In fact, comma, it is submitted that the prime accused has died in judicial custody. Full stop. Next para. Learned Counsel further submits, comma, by placing reliance of the judgment of the Honorable Supreme Court in Dr. Rajinder Rajan versus Union of India and another, that if the constitutional mandate of informing the arrestee the grounds of arrest is not complied with, comma, the arrest and subsequent remand would be rendered illegal and the person would be at liberty to be set free. Full stop. In such view of the matter, comma, it is submitted that since the end of the trial is not in sight and due to the contravention of the aforesaid constitutional mandate, comma, the petitioner should be set free on bail, comma, if necessary by imposing stringent conditions. Full stop. Next para. Learned Public Prosecutor seriously opposes the prayer for bail and submits that the gravity of the offense and the heinous nature of the crime cannot be denied. Full stop. The charge is that of the murder of a 35-year-old reporter who was brutally assaulted and thereafter killed. Full stop. The corpse, CORPAC, was concealed and subsequently burnt. Full stop. Next para. It is further submitted that the prosecution apprehends that if let free, comma, the petitioner has every possibility of influencing witnesses and tampering with evidence. Full stop. Next para. Thus, comma, Learned Counsel seriously opposes the prayer for bail. Full stop. Next para. It transpires from the submissions of parties and copies of 2 applications which are handed over by Learned Counsel for the petitioner for the perusal of court that at present, comma, although the charge sheet and supplementary charge sheet have already been filed upon completion of the investigation, comma, 2 applications at the behest of the prosecution are pending, comma, respectively for necessary permission to take photographs of all 4 accused persons who are presently in judicial custody, as well as for taking their voice samples. Full stop. Next para. Although the petitioner is one of such accused persons, comma, and the allegation of conspiracy against the petitioner is found from the charge sheet and the supplementary charge sheet, fact remains that following the principle reiterated in Dr. Rajinder Rajan Supra, comma, in view of the non-compliance of the constitutional mandate of informing the petitioner the grounds of his arrest, comma, the petitioner is otherwise entitled to be set free, comma, since the process of arrest and subsequent remand was vitiated for such non-compliance. So next para, in Dr. Rajinder Rajan Supra, comma, the Honorable Supreme Court also took into consideration the judgments of Mihir Rajesh Shah versus State of Maharashtra and another, comma, reported at 2026 1 SCC 500, comma, where the principle that the constitutional mandate of informing that non-compliance of the constitutional mandate of informing the arrestee the grounds of arrest vitiates the arrest and subsequent remand and renders the same illegal, comma, entitling the person arrested to be at liberty to be set free. So next para, even otherwise, comma, there is serious apprehension that the trial will take a prolonged period, since out of the 84 charge sheeted witnesses and 14 witnesses mentioned in the supplementary charge sheet, only one has still been examined, and for the last 7 months, for various reasons, no witness could be examined. Who served? The petitioner is already in custody for 1 year, 20 days, and as the investigation is already completed, no useful for purpose would be served in retaining the petitioner behind the bars for the present. Next para. However, the court is not unmindful of the gravity and heinous nature of the offence, as well as the fact that the photograph and voice sample of the petitioner is required to be taken, and the possibility of the petitioner influencing the witnesses or tampering with evidence has to be curbed. Such purpose, however, can be subserved by introducing stringent conditions for the bail. Next para. In such view of the matter, CRM within bracket N3 of 2026 allowed, thereby granting bail to the petitioner. What is your occupation otherwise?
I am a mason. House construction of mason.
The is allowed, thereby granting bail to the petitioner on condition that the petitioner furnishes bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local and shall not leave the territorial jurisdiction of the South Andaman district without the leave of the jurisdictional court. In any event, even in any event, with or without such leave, the petitioner shall not enter into the Diglipur area throughout the period of trial, and or try to contact the witnesses and or tamper with evidence in any manner whatsoever. So next para. Furthermore, the petitioner shall report to the Aberdeen police station every alternative day during the period of trial, and shall make himself available as and when required, for the purpose of recording his voice sample and taking his photograph.
Already not done.
If not already done, and shall attend. And shall read the document. It is further stipulated that if so called upon to by the trial court, the petitioner shall attend the trial, however, in which case during the short period when the petitioner attends such trial, the petitioner shall report to the local police station closest to the trial court. Next para. This.
And the place of Diglipur, north and middle.
The district. The area of Diglipur, the territorial jurisdiction of North and Middle Andaman. Great. Thank you. To the satisfaction of whom? Chief Judicial Magistrate. To the satisfaction of the learned Chief Judicial Magistrate, Mayabandar. Mr. Ilango, can you furnish copies of these for the records?
My lord,
You take back, this is the original copy.
I'll give the photograph.
As soon as possible, give photographs.
Item number. Item
number 4.
Yes. I put the response. The petition is to appear in person because he is from HON'BLE. He is present today. And while matter was actually he is present today.
Oh, I see.
But when the matter was hearing, because he could not able to place the facts correctly before the watch, the court has directed me to assist the court. And Lord, the papers are with him, so I have tried to contact the reason remote range, not able to contact. as I not the court has dismissed for default. So he has filed a restoration. And he has brought all the papers to him, Lord, Lord, it's within time, Lord, it is.
Registration application is.
Grand who is that?
Yes, Mr. Kormakar, you are appearing for this. You are allowing the registration. Your opposition is recorded.
Because some fabricated allegation against the police officers. Since long ending pending, concurrent finding, 156 rejected. Prefer an appeal, that was dismissed. Then with some allegation and
Decide on merit, sir, because he has brought the only allegations that he has been called at the police station and treated you to be a Bangladeshi. And after later on when he produced the documents, they have found that no, he is not a Bangladeshi, he is a resident of this. And they have been kept for 2 days in the police station. For what purpose they have been holding it? He has sought for the CCTV pages also, they are not providing.
What has he challenged here?
He has challenged an order. Well, he filed an application for the Honorable Chief Justice and I want this 6 to register an FIR. That has not been considered. Rejected, then we went to the district sessions. District and sessions court has found the order by the past with C.
So you want the FIR?
Against that order, both the order come.
The FIR, the complaint is against the police officer.
Yes.
inquiry was conducted, nothing was found.
So why shouldn't you, if you lodge a complaint, you are duty bound to, if there is a cognizable offence, you are duty bound to register. Just because you are a police officer.
Without any crime of the same disclosure. Not disclosure of the cognizable offence also. You are
Complaint-
actually interrogated, Lordship.
Complaint is annexed to your revisional application.
So the application is this is only the grant has been Lordship fixing it for and
The restore can that be then it
can be restored and fixed tomorrow. This
Very well. Then counsel for the petitioner contends that the petitioner had been appearing in person and, comma, being a layman in law, comma, was not able to properly assist the court, which subsequently Mr. Rakesh Kumar, comma, learned counsel appearing today on behalf of the petitioner, comma, assisted him as per the observations of the court, full stop, by the order dated March 17, 2026, comma, the revisional application was dismissed in view of there being no communication between the petitioner and Mr. Kumar, comma, learned advocate. Full stop, next para. The prayer for restoration is consequentially, comma, the revisional application was dismissed for default. So next para. Learned counsel appearing for learned public prosecutor appearing for the state opposes the prayer for restoration. Full stop. However, comma, upon giving careful consideration to the case made out in the restoration application, comma, the court is sufficiently satisfied that in view of the petitioner being a layman and there being some communication gap previously between him and the learned advocate assisting him, comma, the revisional application could not be properly conducted before this court, which led to the dismissal. Sufficient reasons, comma, thus, comma, have been disclosed for restoration of the matter. Accordingly, CRAN 2 of 2026 is allowed on contest, thereby recalling the order dated March 17, 2026 and restoring CRR 6 of 2025 to its original file and number. Full stop. CRR 6 of 2025 shall be listed tomorrow.
Right.
Mr. Kormakar, be prepared to show the court that no cognizable offence has been disclosed in the complaint. The complaint copy has at least has to be. I've kept it tomorrow if you have difficulty. Monday, very well. Tell it tomorrow na kore Stephen listed on April 27, 2026. প্রথমবার যখন সিআরআর আসে তখন হিয়ারিং আসে না মোশন এটা অ্যাডমিট হয় it was never admitted formally তাহলে তুমি একটু মোশন হিসেবে রাখো। মোশন হিসেবে রাখো। মোশন।
I think was admitted. Final hearing it was happened.
Final hearing.
Maybe I don't know. I think
দেখে নিও যে আমি হেডিং কিছু বলিনি, যে হেডিং এ আসবে যদি অ্যাডমিশন হয়ে থাকে তাহলে হেডিং হিয়ারিং আছে, আদারওয়াইজ we'll check up if it was admitted. Grand disposal. তারপর right. না legal aid হলে সব admission হয়নি, will appear as a motion.
Item number 5, there are 9 of 25.
So I appear for the petition. Not here, this person was granted bail by the Honorable Court in the month of December 2025. That is on 19th of December 2025. In a case under sections 3/4, 7/8 and 11/12 of POCSO Act. But at the time of granting bail, that is around 4 months before, there was a condition that may kindly come to page number 10.
Yes.
Petitioner shall not live in the village where the victim resides. You know, both the victim and the accused were belonging to the same school. The victim and the accused resides at Kalbagan, which is within the jurisdiction of PS Higlipur.
You were a student of the school.
So I was a student of the same school. Now I am aged about 23 and I'm working as a machine lord. It is mentioned here. And we see.
What was her age then?
Her age was 17 years and on.
And you were
I was
18 must be.
I was 23 years. I have completed the school and I was working as a daily labor mason.
Oh, you were working as a mason in the school.
Mason in my village.
Yes, at the time of the offense also.
Yes. Now, my lord,
Yes.
kindly come to page number 4. My lord. Page number 4. Para 30.
Yes.
No, they both are residing around 5 kilometers away from each other. From the date of this particular order, I have been regularly going and meeting. I have not entered into my village where my parents reside. I have mentioned the reason for me to allow to go there and meet my parents. My parents, my old grandparents. I have mentioned the reason at para 8.
No, but Mr. Ilango, in the bail order itself, it was stated that shall not enter the village without prior permission of the court. So, on a case-to-case basis, you can take
Permission, but only for 2-3 days. Without once in a week at least.
So you take permission from the jurisdictional court. That liberty is there. Why should there be modification?
Whether it is this court or it is a trial court, because it has been mentioned as the court. That is the problem.
We'll clarify that it will be the jurisdictional court. This dispose of this will not say dismiss. We'll say dispose of with liberty to you to comply with by
Before the trial court, that
trial court will I'll clarify that.
that may be mentioned so that I can move necessarily.
Yes, either otherwise will be remediless.
Yes,
Neither before this court nor before that.
that.
We'll say that. This will mean the trial court. So that is in charge of the trial. It's a better court to decide.
Presently, at least for the limited period, at least on Saturdays and on Sundays, I may be allowed to go and meet my parents.
What is the age of your parents? You are 23. You are
My parents, I have mentioned here. Page number 3, para 8 and page number 4, para 9. Problem is that I am residing in a rented accommodation. Leave that. I will.
No, somebody else must be there in your family.
Their old aged parents are there. Apart from that, my grandparents are also there. For the last 4 months after
You can file an application only on Monday before the jurisdiction court do it. Not before.
2 sisters are the week. Yes, should not.
2 sisters are
2
the
sisters are the week.
no 2 sisters, not his sisters.
My lord, if I go by the merits of this case, my lord, the case was chalked out after a period of 24 days.
Maybe.
From the date of
Kindly see
No, Mr. Ilango, still we cannot deny that still in Indian society there is a stigma attached to these things. So
the.
there may be a delay in. So we are so go before the trial court. It's in charge of the trial.
That clarification may kindly be
Immediately,
given so that I can be.
Sure.
But
The petitioner seeks a modification of the conditions of bail as imposed by the order dated December 19, 2025, passed in CRN 9 of 2025, to the extent that the petitioner, who was directed by the court granting bail not to live in the village, live in the village where the victims reside, and shall not enter the said village without prior permission of the court, be modified to the extent that the petitioner be allowed to visit his village for the limited purpose of meeting his ailing parents and aged grandparents. Gustav, learned counsel for the petitioner submits that apart from the petitioner, there is none else to look after them in the family, and as such limited modification may be allowed. So next para, learned public prosecutor appearing for the state opposes the prayer for modification and submits that the nature of the offense was grave and the two victim girls may be in jeopardy if the petitioner is permitted to enter his village, where the victim girls also reside. Next para, upon consideration of the submissions of parties, it transpires that in the order dated December 19, 2025 itself, as one of the conditions of bail, the learned single judge had restricted the petitioner from living in his village and or entering the village, where the victim girls also reside, without prior permission of the court. Next para, since learned counsel for the petitioner submits that there is some ambiguity as to what was meant by the term double inverted court, C capital, double inverted clause, as it may be either this court or the trial court, I hereby clarify such doubt to the effect that by double inverted court, the or the learned single judge meant the trial court, since it is in a better position to assess the circumstances to decide as to whether the petitioner should be permitted to visit his village, depending upon the stage of the trial and the evidence before the court. Next para, accordingly, with such clarification that the petitioner will be entitled to seek prior permission of the jurisdictional trial court in terms of condition number Roman 2 as imposed in the order dated December 19, 2025 for the purpose of entering his village, the present application is disposed of. So, next. Yes, sir.
Along with the appeal, I have also filed a CAN application. There is a delay of 1,195 days.
Only. So what is
I
the?
cannot put only that.
It is appealing for the first time.
No, but it has already appealed. The other side has already filed the objection also. Mr. Mishra is appearing in the matter.
Will you file a reply?
Yes, Lord. That opportunity I want to use.
So we are giving you 1 week and it will appeal in the next. Okay. Learned counsel for the appellant stroke petitioner seeks an extension of the time to file affidavit in reply with the opposition used by the respondents against the condonation application. Accordingly, the appellant stroke petitioner is is directed to file his affidavit in reply in respect of the condonation application wherein can 1 of 2025 within a fortnight from date, liberty to the parties to mention the application before the appropriate bench in the next circuit for enlistment. Thank you.
Number 7, theorem.
Yes.
I know this.
Right.
Okay. Before granted clear to the petition.
The report was to be submitted.
Yes, sir. With regarding to my address.
You seek a modification of the condition of
Yes.
bail. What is the nature of modification?
But with regarding my I can meet the any SHO in the South Andaman because
Pardon? You may meet
my condition was to meet the SHO concern.
Yes.
In Campbell.
every day except Sunday.
Every day. I'm regularly complying those conditions. No, there is was adversity. My only conception is that because there was no source of income, I'm compelled to reside there in the hotels. Those expenditures which I cannot make any income.
Where did the offense take place?
It takes place in PS Pargaon.
Pargo is where? Near
South
Margo?
Andaman.
Yeah, South Andaman. So you are a resident of?
I'm a resident of mainland. I'm from Tamil Nadu. I'm not seeking any.
So what are you wanting now?
I want any otherwise in Solasdeep or Shaidip, I get an employment, I can be reside and regularly meet here.
Have you got an employment?
No, because of I've not got, I have to try. I have to come because in the Camel Bay there is no source of income, so I can generate. So it's very difficult.
No, but on an apprehension, on a probability, we cannot grant. If you find an alternative,
Because I can't leave the PS Camel Bay without the permission of the.
so what sort of modification are you wanting?
I'll be there in the South Andaman district and regularly meet the daily. These conditions be there, but other people.
Which police station?
I want maybe PS Satam or Bumflat PS Bumflat.
What do you say to this?
I oppose what happened. Yes, so murder. Young lady was murdered. 2 persons, husband and wife, conspired, engaged 6 to 7 accused persons from mainland Madurai. Payment has been made.
Supari killer.
Super killer. They reached the Port Blair. In daylight, on open place, that lady was badly assaulted by sharp weapon. For that reason, Lordship, for that reason, all the accused persons were granted, imposing some stringent condition. These accused were, the condition is remain in Camel Bay, another 4, one is at Middle Andaman, one is at HON'BLE. By that fashion, court has allowed the condition.
So what was the reason for his directing to meet the PS Mayabandhu? Because he was there at that point.
No.
Why particularly Mayabandhu?
Camel.
Campbell.
Camel.
Why Campbell be in particular?
Because it is a isolated, separate from place of occurrence. So all the accused person conspired, came, reached Port Blair, different places they have.
You can put him in some other place. I mean,
Lordship, Campbell, because no.
you are wanting Swarajdeep or Bamboo Flat is in South Andaman only.
Otherwise,
Swarajdeep is an isolated island. I mean, he has to come here.
Lordship.
Not so isolated, but
Easy come and go. Lordship. Place of occurrence as Batugusti, Port Blair jurisdiction. Easy to come and go from the Swarajdeep.
if he wants, he can come from Mayabandhu also. What is the difficulty? Every day people are coming here.
This court found no different island is there. So 5 accused persons, 5 different.
No, sorry, he's in Campbell Bay.
Campbell Bay. And good place,
Good
let
place.
it remain there.
No, but
Because time
job opportunity is limited in Campbell Bay, obviously.
Lordship, this type of works available better than Port Blair.
Campbell Bay, from Campbell Bay to Port Blair, there is no conveyance.
Yes, ship is there 3 days.
What is the frequency? In 3 days.
Yes, ship, by ship.
He has to have a ship only. He cannot come by helicopter.
Even the solar ship has to come by ship. Lordship, that is my objection. Not Swarajdeep, not Leland. Near to the place of office. All the witnesses belong to the.
So near is a very vague term. But you also, I mean, we can for the time being, Mr. Gormokar, then we have to relax his bail it is each and every day. If he has to report at Campbell Bay each and every day, then he cannot search for job anywhere else.
That I cannot say. That I leave this.
So if we make it once a week, so that he can go and search for something.
Course, but he may remain at Campbell. That
No.
modification should not be.
No, then he has to leave Campbell Bay for search.
No, Campbell is different island. Once when he came meeting with the IU, no problem. Or meeting with the SHO.
But for the rest of the time, he can leave Campbell Bay for his work.
No, the condition is not to leave the
Which page?
page number 7. The condition
7.
in the cran.
What I mean is March 2026.
Remain within the jurisdiction of Canada. In Campbell Bay, there is what sort of attempts you have made to search for a job in Campbell Bay? We don't have anything on record.
The thing is,
What is your special? What do you do
I have a
in Chennai? What did you do apart from super killing? Of course, this is a field of specialization by
I
itself.
have a driving license.
Campbell Bay, there can be
But
also.
there-
See, there is nothing concrete to show the court that in Campbell Bay there is no job opportunity. We are not aware at all.
The rest thing, then there is no any kind of private opportunities there to seek any kind of job. Here in Swarajdeep or Shahideep, there is an opportunity of both private sectors. So I'll Your Worship, I will go and put my signature every alternative is. I second my attendance, I will give my present address to the concerned SHO and the client would below us. Some relaxation which will help me.
On Sundays, you can.
Only on Sundays I have been.
No, but you have been given the permission, you have been given the leave not to leave such place without permission of the district and sessions judge. So take that leave from the sessions judge. But prevents you from doing that. That is incorporated in the condition itself.
Yes, sir.
He shall remain within the jurisdiction of Campbell Bay police station and shall not leave such place without permission of the district and sessions judge. So that is already there. Why should we modify this?
That could have given a.
Trial could have move the trial code because it is in a better position to assess the risk. Will not modify. We'll say we'll dispose of by clarifying that you already have that leave to approach the district and sessions. Learned counsel for the petitioner submits that the condition of bail imposed in the order dated February 10, 2026 in respect of the petitioner, to the effect that the petitioner cannot leave the jurisdiction of the Campbell Bay police station without permission of the district and sessions judge, Port Blair, excepting for the purpose of attending court proceedings and to meet the station officer, PS Campbell Bay on each and every date, excepting Sunday, be modified because it is contended that the petitioner has a driving license, but there is utter lack of job opportunities in that field in Campbell Bay, which is cut off from the rest of the South Andaman district. So the next para, accordingly, learned counsel seeks a modification permitting the petitioner to leave the jurisdiction of the Campbell Bay police station for the purpose of seeking exploring job opportunities. Whose of next para, learned public prosecutor appearing for the state opposes such prayer and submits that due to the security risk involved, in the event the petitioner is permitted to go out of Campbell Bay and influence the witnesses who reside in the district of South Andaman, the coordinate bench consciously imposed such condition and the same ought not to be diluted. Next para, in any event, the court finds from the order dated February 10, 2026 that as a rider to the restriction on the petitioner to leave the jurisdiction of the Campbell Bay police station, the petitioner was permitted to so leave with the permission of the learned district and sessions judge, Port Blair. Full stop. Next para. However, if the condition of reporting every day to the station house officer, Campbell Bay Police Station is retained, it may be impossible for the petitioner to leave Campbell Bay to search out job opportunities, even if such permission is granted by the district and sessions judge. Full stop. Next para, we are modifying to that limited extent, he will report once a week. In such view of the matter, CRAN 1 of 2026 is disposed of by modifying the order dated February 10, 2026 to the limited extent that instead of each and every day as mandated by the said order, the petitioner shall report once every week to the station house officer, PS Campbell Bay. Full stop. Next para. It is made clear that the petitioner will also be entitled, in terms of the order dated February 10, 2026 itself, to approach the jurisdictional court, that is the court of the district and sessions judge, Port Blair, to seek permission to leave the jurisdiction of the Campbell Bay Police Station upon sufficient satisfaction of the said court to that effect. Full stop. This. So once a week, and you can approach the district. Thank you.
Item number 8, theorem 8 of contract section.
Proceed. Maybe tomorrow, I want BC on judgment category.
Sure.
Tomorrow. One can, one BC judgment.
Absolutely. You're for the state of this. On the prayer of learned public prosecutor, the matter is adjourned for the day. Okay. Give your name also.
Item number 9, 08.
It's an application for review, my lord. It has to be sent to my lord Justice Chetan.
Right. Learned counsel for the petitioner rightly points out that the application pertains to the review of an order passed by Choitali Chatterjee Das J. Accordingly, the office, registry or office, the registry is directed to take appropriate steps for placing their matter before the said bench. Thank you.
Item 10, recipient continue coordinator with
Contempt of whose order? Mosumi Chatterjee was never a judge of this. Yes. So therefore I can take up. Yes.
Yes.
Right.
Last question, worship, the other side is submitted that matter is pending before the Honorable Supreme Court. Right, given the battles of
Against the parent order. What is the stage of that status of that?
Worship that.
But we have enforced page 36.
How far that case is?
Page 36 or
36.
of what?
That
Is
is
compliance such.
But,
If you have complied, then
They have not complied with it.
no, against the learned single judge, you went directly up to the Supreme
No,
Court.
they went to the petition bench.
Affirm.
Affirm.
that is writing content is page plus the case.
Oh,
Now, the Supreme Court's direction has come. That way, Supreme Court has said the earliest has to be paid from the cutoff date to up to October 2020. We have to done it in September.
Yes, that case has got nothing to do with my case.
But as per the cutoff granting that.
So that is a different case. I was not a party in the case.
no, this particular order did not go. I mean, against this, the challenge against this did not go up particularly before the Supreme
That
Court.
is not.
On same issue, you are saying
Yes, that's got nothing to do with my
One
case.
Sarvajanic union has been filed. In that, the division bench has made.
no, means Nath says that there is nothing that has nothing to do with
Yes,
this case.
because it's not the case. How that order will be applicable to me?
Because it comes to Supreme Court's order. Period which has been granted because those DRMs are similar because all the DRMs have been paid. So as per the Supreme Court's order, we have to pay it from March 2017. We have paid it.
So you say you have complied?
Not that. Not to kindly come once that Supreme Court's order.
Yes.
Lord, it is at page 28.
Right.
But prior to that 27, last line was the taken consideration.
Yes.
Moreover,
Yes.
the order 2276 stipulates the arrears shall be payable from 1st September 2017 to 8th September 2023 to 410 DRMs.
No, you say you have complied.
Now, in terms of this, as we have to take the cutoff from 1st September 2017 to 8th May 2023, we have paid it. And the para 12, it has to.
But you have not preferred any challenge against the division bench judgment.
Single division bench, we prefer appeal.
No stays here. And how many years I have to wait?
See, Mr. Kumar, we understand what you are saying, but in contempt jurisdiction, we cannot go beyond the order under contempt, right? You know that it's a well-settled provision. So whatever has been directed, we cannot go into the question whether that order is justified, legal, because your argument hinges on that. If the Supreme Court in another case has held it, it's a legal argument that it should be binding in this case also. It's a legal argument which Ms. Nag is definitely entitled to controvert. But you have to take that in your appeal. The appeal pending before the Supreme Court. What is the stage of that appeal? We cannot wait indefinitely.
4 years.
Then
I'm waiting for 4 years. It's pending only. They're not even obtaining interim order.
these are, you are also DRM.
Yes.
These are DRMs, Mr. Kumar. We cannot make them wait indefinitely. Their livelihood is depending.
Not next application. Let it be on Monday. Let us see what happens.
What is the stage of that appeal?
Simply they are filing it and
You have to
filing it.
file
For 4 years.
Yes,
it's
the
done.
only question is not because out of this DRMs, sub 6 has been come to the zone of consent. This is the only right.
No, we cannot go into that question. You have to comply as it is, unless you have taken steps in the appeal. We cannot look at those things. The judgment of the Supreme Court. We are in contempt jurisdiction. We have a very limited charter.
Your contempt application was filed in 2022.
So you file something on Monday, Mr. Kumar, to show what is the stage of that appeal and what steps you have taken.
Yes.
Today we are on Thursday. You get tomorrow. Monday we'll take it up. So a single bench will be after 12. So Monday 12 till then you file a 1-page, 2-page affidavit. Whoever is the stage of. Learned counsel for the petitioner submits that the contempt application has been pending for the last 4 years and has been stalled due to the stand taken by the alleged contender that challenge is pending before the Honorable Supreme Court against the parent order in respect of which the contempt has been initiated. So the next para, learned counsel submits that the petitioners cannot be made to wait indefinitely due to the pendency of the appeal before the Honorable Supreme Court, particularly since it has not been placed before the court that any order of stay has been passed. So next para, learned counsel for the alleged contender submits that in other matters pertaining to the same issue as the parent order, the Honorable Supreme Court has passed certain judgments which govern the present case as well. Accordingly, the alleged contender has complied with the said order of the Honorable Supreme Court, which will be evident from the affidavit of compliance filed by the alleged contender. Next para, learned counsel for the petitioner opposes such prayer and submits that the judgments of the Honorable Supreme Court cited by the alleged contender has nothing to do with the present case, and there has been no compliance of the parent order in this particular contempt application. Next para, although the alleged contender may have the court is of the opinion that although the alleged contender might or might not have an arguable case in the appeal preferred against the parent order on the strength of the judgments of the Supreme Court passed in other matters, it is beyond the charter of the court, sitting in contempt jurisdiction to look into the legality or merits of the order under contempt. Full stop. The court, comma, in such jurisdiction, comma, is only to see whether the parent order, comma, as it is, has been complied with in full by the alleged contender. Full stop. Next para, we also agree, the court also agrees with the submission of the petitioners that the petitioners, comma, in view of their plight, comma, being daily rated Mazdoors, comma, cannot be made to wait indefinitely for merely due to pendency of an appeal before the Honorable Supreme Court. Full stop. It is well settled that mere pendency of an appeal does not automatically operate as a stay of the impugned judgment. Full stop. Next para. Accordingly, comma, to ascertain the stage of the appeal, comma, the alleged contender is directed to file a short affidavit on the returnable date, comma, upon service of an advance copy of the same on the learned advocate for the petitioners, comma, disclosing the exact stage of the appeal pending before the Supreme Court against the parent order, as well as to what steps have been taken by the alleged contender in the interregnum for early disposal of the appeal, comma, if at all. Full stop. The matter shall next be listed on April 27, 2026 for passing further orders.
Thank you.
Give an advance copy to them, sir. Which one? Yes, yes. এটা call করো 115 যেটা বলেছিলেন।
Lord,
ID
this
number?
matter,
130.
this matter, I am appearing for the FRRO, Lord. Lord, I have a humble request. Just half an hour back, Lord, I got instruction to appear. Can it be on Monday? Can it be on Monday, Lord? Half an hour back, I got the brief.
This item number?
Because FRRO Chennai,
দাও ফাইলটা তো একটা বলেছিলেন তো ফাইলটা আলাদা করে
I'll just tell you, Lordship, in a nutshell.
give us half a minute, Mr. Mujinda. Let me have the file first. মুভিংটা কিচ্ছু বোঝে না মুভিংটা কিচ্ছু বোঝে না কত নম্বর What is the matter about, Mr. Kabir?
My lord, in a nutshell, I'm born in India. I'm a resident of the islands. I go abroad to study. While I'm there, I surrender my Indian citizenship and I obtain Canadian citizenship. Come back here, I now need a visa or a document. So I get an extra long-term visa to come back. Now, once I come back here, my parents are from here, I live here, everything is here. So I apply for an OCI card, Overseas Citizen of India. I'm granted that card. That card operates as a long-term visa, allowing me to stay in India. Now, in 2020, I go to Nicobar on a trip. Now, this is probably the most interesting case I've done. Now, Nicobar and the whole of the Andaman Islands is a restricted area. In 1963, the foreigners restricted area order made the whole of Andaman restricted. So, any foreigner who comes into the islands needs what is called an RAP, restricted area permit. This was denotified in 2018, and certain islands were no longer restricted. Now, the island I visited in Nicobar is no longer restricted. Now, in 2020, I go to that island in Nicobar, Nankod. I have an Aadhaar card. Now, an Aadhaar card is not an Indian citizenship document. Any resident can have it. I apply for a tribal pass. I'm asked to show my Aadhaar card. I show it, I go. In 2020. Now, kindly see the show cause notice given to me first.
Now, what is the extreme urgency, Mr. Kabir?
I'll tell you. Now, a show cause is given to me in 2024, saying when you went in 2020, you violated a notification of 2021. 2024 show cause saying you went in 2020, but the notification you violated is of 2021.
So,
I explained that in my reply.
No, what is the implication of that? I mean, what is
The
the?
implication is the notification I'm supposed to have violated didn't exist when I went.
No, not that. No, not the,
Now-
that argument I've understood. I mean,
No, so
what
the
is
show cause,
what is the fallout of that?
Now, the fallout is I gave a reply.
Because I record the urgency. What is the
Well,
urgency?
the fallout is I gave the reply. They sat quiet. Now that notification didn't exist, so that ground was tenuous for cancelling my.
Yes. So what do you have?
FIR is registered
Yes.
saying that I passed myself off as an Indian by showing the Aadhaar card. And now my OCI card is cancelled without hearing me, without anything, leaving me high and dry. Today, I'm a Canadian citizen in Andaman. But with the cancellation of the OCI, I have no legal status in India.
So you may be directed to leave India immediately.
I
That
may
is
be
what-
deported at any point.
So that would take some time. I mean,
No,
what's the
that's
extreme
the
urgency?
second problem. The first part of the deportation is in the order that has been passed. I have been told, go and surrender your OCI card at Chennai. It is cancelled. Kindly visualize a foreigner who doesn't have a document to stay in the country is in violation of certain laws. I can be picked up tomorrow, today, anytime.
Well, that situation I shall take care of. Well, kindly take up this matter on Monday.
Well, we'll record it to your submission then, Mr. Mujinder.
Yes.
That no coercive steps will be taken on the basis of the.
In the meantime, yes.
In the meantime, yes, obviously.
Oh, I did not
Take
realize
Monday,
Mr.
take Monday.
Mojumdar is appearing. So if Mr. Mojumdar is appearing and if he is undertaking that there will be no coercive action, madam, then the matter can come on Monday at the top. Because I'll show your worship a point of law.
Difficulties, Mr. Kabir, I won't be able to decide this matter.
No, it's not about deciding. I'll tell your worship why.
For passing an interim order, I'll have to hear the entire matter.
My lord, may I say this? I'm on a very simple point of law here. There are two
Your
parts.
simple points of law, I've understood, ma'am. Please.
My lord, I'll finish it in 5
Your
minutes.
academic and nuanced,
In-
simple questions
in
of
five-
law, I've understood.
in
And
five-
my lord, he appeared.
I'm
He appeared.
sufficiently experienced to understand that.
In 5 minutes, I will.
You and Mr. Mujumdar in 5 minutes.
No. And the point of law is this.
In person.
The point of law is this. The Citizenship Act requires before you cancel my OCI.
No, Indians also have a right to personal liberty and their own time. And judges too.
The simple thing is, I'll make it in a nutshell. The charge sheet came in February
No, well, if you hear it on Monday, then no courtship action on what?
on the order, impugned order.
My lord need not record anything. It is my assurance, my lord, nothing is going to happen, my lord. By
No,
Monday.
Mr. Mujumdar, something should be there.
Page 221 is the.
Yes, tomorrow if you see that you are removed and somebody else comes in.
No,
then-
because he has to surrender his OCI card before the authority, my lord. That I will instruct. It has already been cancelled. It is not that it has not been cancelled. And my lord, the opportunity of hearing was given to him. The opportunity of hearing was given to him. He appeared, my lord.
No, Mr. Mujumdar, what we are tentatively thinking about is that you will no coercive action shall be taken against him pursuant to the cancellation of his OCI.
Hmm.
That is what till Monday.
Well, instead of Monday, can it be on Tuesday? Monday, my lord, I have some.
This is the last day we have. Then
No,
this state order, this undertaking will record till the end of June or until further order, and we will put it in the next circuit.
That would be better.
Helps
Let
me
it
also.
be on Monday. Let it be on Monday then.
Monday. All right. So my negotiation skills are very good.
No, my lord.
Almost as bad as my timekeeping skills in Andaman.
Yes. No, worse. Learned VSGI appearing on behalf of the respondent authorities seeks an adjournment till April 27, 2026 on the ground that he has only been recently briefed in the matter. So next paragraph. On the query of court, learned VSGI assures the court that till April 27, 2026, no coercive steps shall be taken against the petitioner on the pursuant to the cancellation of his OCI card. Full stop, next paragraph. In such view of the matter, the matter is adjourned and shall next be listed at the top of the list on April 27, 2026. Other কোনো matter কি fix হয়েছে? Then fairly at the top.
So this matter will be taken up at 1 PM or 10:30.
Mr. Mujumdar, what we are doing now, we are sitting in division bench till 12.
Okay.
After 5-10 minutes from that, then we take up these matters.
Lordship, after 12.
10 approximately.
Yes, yes. After 12 anytime.
Follow. Sierra. Fairly at the top. This will be the second top matter, Mr. Kabir and Mr. Mujumdar. The other one is probably a short criminal division. So this will be the second top.
I'm very grateful.
Yep.
I'm appealing for R8, 6 and 7.
Give your names, all of you.
6 and 7 as per the.
You are appearing with any one of you is appearing with Mr. Mujumdar?
Yes, my lord, Mr.
Independently, all independent.
Mr. Rakesh is there.
Mr. Rakesh is there. He doesn't know that he is there. I mean, he doesn't know he was there.
I'm appealing along.
No, Mr. Rakesh now agrees. Yes.
But it is possibly the most interesting matter.
No, I am not interested in interesting matters of the last 2 days of my exam.
No, I'll make it very short.
I am very academically interested.
I'll make it very short.
Up to 2-3 days before the last day.
I'll make it very short.
Very good.
Give you.
Let's come back to that. Yes. Mr. Mujumdar, you come prepared.
Lordship.
We found it as usual for you and Mr. Kabir also.
Lordship.
Great.
Next.
Item 12, CPN 30 of 2024.
Yes.
That's the for the petition.
Right.
The petition order passed by Honorable Justice. I will put it up. The order passed in year 2023.
That's why IPM Mukherjee is Indian, of Indian origin. He's of Indian origin, not a Saab.
Yes.
Yes.
So in this case, I'm taking short time, Lord, if you on Monday, I will.
To comply with the order.
No, we have already complied.
Order 24, the contempt application fact.
No, he's saying, Mr. Sevalan saying he
Monday.
may have already complied.
They have applied it partly.
What was the nature of the order?
The
Payment.
page number.
Payment.
Release the interest amount. We have released the interest amount.
Page number 25. Lord.
Mr. Sevalan, you collect the documents, we keep it on Monday.
Well, they have already filed the complaints application, but according to it only, they have not paid the balance amount of 3,20,000.
No,
I'll
subsequently,
release the details.
Learned Counsel for the alleged contenders seeks an accommodation to take instructions as to the current status regarding compliance of the order under contempt. Which is the next para? Accordingly, let the matter stand adjourned till April 27, 2026. Come back. Thank you.
Number 14.
Who's ordered? Who's ordered?
It is so many same. Well,
You want to file a reply?
yes, sir.
You are for the petition.
Petition.
Affidavit already filed. Opposition.
Is the reimburse the amount. But we are not done, so I indicated the list of documents required.
You have filed that already.
Yeah, if I already filed a lordship.
They want to file a reply.
You have filed it in the form of a very Learned Counsel appealing for the petitioner seeks to file. How long? 1 week.
1 week time.
Learned Counsel for the petitioner seeks to file a reply to the affidavit in compliance filed on behalf of the alleged contenders. Accordingly, let the matter stand adjourned till the next step.
Well.
The time for filing reply is extended for a week from date. Thank you.
Item number 15. Statement 26 of 2026.
Okay, बोला था
The order passed by one of the trustees.
Since the matter, since the contempt application pertains to an order passed by Arindam Mukherjee ji, the registry is directed to place the matter before the same bench. Yes, they can now. The bar requested me to rise at 1:30. We have still 3 minutes. If we can finish anyway.
Item 16, WP 96.
Learned Counsel for the petitioner submits on instruction that the petitioner seeks to withdraw the writ petition. Because accordingly, WPA 96 of 2026 is dismissed as withdrawn without any orders to costs.
17. WPA 102 of 2026.
Lordship, I am for the petitioner law. It's a grant of electricity. Electricity lordship, this is
Service-
part of the litigation.
Service
Only comes to they have filed the affidavit of opposition, they were fit for hearing, Lord.
reply, you are not filing it.
No, no, nothing, sir, is for the opposite side lordship. It is a third round of litigation for anti-steal.
We'll adjourn it for the day only. None appears for the petition, respondents at the time of call, although the petitioner is represented through counsel. Then counsel for the petitioner pleads urgency and submits that there have been several previous rounds of litigation and the matter is required to be heard immediately. Next para. However, keeping in view the absence of the respondents, the matter is adjourned for the day. It is, however, made clear that in the event the respondents do not appear on the next occasion when the matter is taken up for hearing, ex parte orders may be passed in the absence of the respondents. The learned advocate for the petitioner is requested to intimate the gist of this order to his counterpart appearing for the respondents during the course of the day. Today itself, intimate to him. Better in writing. It will be taken up tomorrow and without your absence, it will be. Sir, yes, sir.
Yesterday, my lord has heard substantive. This matter with regard to that order passed by the Tahsildar with regard to the Kodi crusher unit. That
Yes.
matter is appearing in item number 1 subs prior to the given because last 3 days, my lord, this matter was taken. So far as item 26 is concerned, I have concluded my argument. My lord has asked Ms. Babita Das as to whether any opportunity of hearing was given before and whether he had a jurisdiction.
26, 27 have to be taken up together.
Yes, my lord.
Tomorrow at the top then.
But
Single, you are appearing.
27, there is that CRZ.
CRZ.
Oh, right. So tomorrow then at the top. Please inform Ms. Das also.
Yes,
Mr. Kumar is there.
Yes, yes.
Ah.